Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right. I have an indie bear on the floor, but she's here with me. Welcome back to the afternoon session of today's hearing. We, of course, are watching the Stand Your Ground hearing for the so-called Black Swan Murder Trial, which has been quite an interesting hearing so far. It's basically like a mini trial because the purpose of the hearing is the defense has requested dismissal on the basis of immunity. Stand your ground. In other words, they are saying that she had a real and reasonable reason to fear her life. She did, in fact, fear for her life in the moment that she did, and she used a certain amount of force that was reasonable under the circumstances. And that is why she killed her husband, Doug. We have heard some evidence about his seemingly anger issues. It seems like, we know that he apparently punched a wall at one point during an encounter during their marriage or during their relationship, I guess before their marriage, during their relationship. And then at the same time, they also, there was an instance where he used his firearm, shot at the ceiling. Whether or not that was intentional or not is not exactly clear to me. But there's also the incident with the dog, that he hurt the dog, whether he punched the dog or pushed the dog off of him very quickly and aggressively. I don't know. Either way, it's still like as an animal lover, as a dog owner, it's hard to listen to and to not judge him for that, to be honest. So if this does get in front of a jury, if the defense does not win with this 2-day hearing, and this does go in front of a jury, that's going to be something that is going to be favorable for the defense, to be honest. I mean, even if it doesn't necessarily prove the point of whether or not in that moment he was being aggressive towards her, threatening towards her. There's a lot of people that are going to feel very, very passionately about that, right? Okay, so we're a little bit behind the hearing. We're not exactly live, but only by a few minutes. They like just got started. So we're gonna go ahead and jump right in. And at some point they'll have some kind of a break and we'll get caught up just like we did last time in the morning session. So to everyone who was here in the morning that is joining us again, welcome back. And to everybody that is here that wasn't here in the morning, welcome. And I think that is about it. I think that's everything. If there's more detail that you want on this, there is information in the description. It's kind of limited, but it's more than what I gave already. So that'll give you a little bit of context. There's also some really good information on Law and Crime and on Court TV on their websites about this. They've kind of been covering it for a while. This is not the trial, by the way. This is a hearing to determine whether or not it's going to go to trial. So, okay, let's go ahead and get started. Okay,
This case to be the truth, the whole truth, and nothing but the truth.
I do.
The audio is definitely different than it was in the morning.
Thank you.
Hello, sir. Hello, sir.
as the deputy said, 12 to 15 inches from the microphone.
Okay.
Adjust it how you need, up, down, left, right, and just loud, clear voice should hear everything.
Yes, sir.
Thank you.
And Judge, we're ultimately going to need the screen. Good afternoon.
Good afternoon.
Please state your name.
Detective Justin Warren,
How do you spell Justin and Warren?
Justin Warren.
Where do you work?
I'm employed by the Manatee County Sheriff's Office.
How long have you worked there?
Started March 25th of 2003, so just over 20 years.
What is your current position?
I'm currently assigned to the Manatee Homicide Investigative Unit.
What is that?
So basically, it's a unit comprised of detectives from the Sheriff's Office as well as other local municipalities. And whenever a homicide occurs within the jurisdictional boundaries of Manatee County, several of our units or detectives will go out to assist.
And generally speaking, when there is a homicide, do all of the members go out?
It depends. Sometimes for people on vacation, other times not everybody will come out. It depends on what the supervisor deems necessary.
But the majority of the time, do you have more than one detective there?
Yeah, oh, yes, ma'am.
Okay. And do you have what's considered a lead detective in cases that you do?
We do.
Okay. And what does the lead detective do?
The lead is essentially the person who will basically hand out assignments. Those other detectives that will be out at the scene, or they might be knocking on doors, talking to witnesses, they essentially report back to the lead and the sergeant.
Okay. So as the lead, even though you may be designated the lead, that doesn't mean you're doing all of the interviews.
No, that's correct.
Okay. Were you the lead detective on the case that we're here about today?
Yes.
Ashley Benefield.
Sorry, yes, ma'am.
Yes. On the date of the shooting, were you notified?
I was.
And around approximately what time?
I think it was probably around 7:20 or so.
Okay. So you were called at around 7:20. Do you know, was there a 911 call?
Yes, ma'am, there was.
And what time was the 911 call?
I think that was approximately 18:56 hours, so 6:56 or so p.m.
So you're there roughly 35 minutes? Or,
Yeah.
or you come to the sheriff's office roughly 35 minutes afterwards?
Yes, ma'am. I started responding there.
Okay.
Yeah.
So I was starting to say that you went to the scene, but you didn't go to the scene first, correct?
That's correct.
Where did you go?
I went to the sheriff's office so that we could begin authoring a search warrant for the residence.
Okay. At that time, did the defendant, Ashley Benefield, come to the station?
She was brought to the station. Yes, ma'am.
Okay. Was she brought to the station by other members of Manatee County Sheriff's Office?
Yes, ma'am. There was a patrol deputy brought her in a marked patrol unit.
Was she under arrest at that time?
Not by me. No, ma'am.
Okay. When you saw her, were there any other people with her?
When she arrived, it was just the deputy and her. But I was soon, actually, before I even met with her, I was actually approached by a female by the name of Faith Brown.
Okay. And did she have other people that joined her throughout the evening?
Eventually, two others arrived. Yes, ma'am.
Okay. Do you recall who they were?
Leland Taylor and a Miss Kimberly Kuhn.
Okay. And they're all three attorneys?
They are.
Okay. At the time, did you have a crime scene technician take photographs of her?
We did. We had a crime scene technician respond to the office. We actually obtained a search warrant in order to get those photographs and DNA and whatnot. But yes, we did.
And why?
We asked, and initially it was told by her attorneys that they would rather us get a search warrant, so we did.
Okay. And why did you want pictures?
So initially, when I saw her, I didn't notice any kind of injuries at all. I didn't notice anything about her clothing that stood out, whether it was ripped or torn or stained or stretched out, things that you would typically see during a physical altercation.
At the time that you saw Ashley Benefield, were you aware that there was a self-defense claim?
I had been aware of what had been said on the 911 call. Yes, ma'am.
Okay. And what was said on the 911 call, and we have a stipulation to this effect, but basically she, Ashley went to a neighbor and said her husband attacked her.
Correct.
Okay.
And yes, ma'am.
So you were aware of the self-defense claim at the time.
Yes.
When you observed her physically, what was she wearing? Oh, I'm sorry.
I request that stipulation be read.
Which one is it?
It's number one, I think.
Number one? Okay.
To answer
Okay,
the-
it doesn't mention 911, but that's ran to neighbor's house, called 911.
Well, Your Honor, I believe it says immediate
their child right now is about 5 years old,
neighbor's house.
born in
Yes.
2018.
Hysterical,
Mhm.
just quite different from what
Oh, okay.
Okay.
I've read it.
So anyway, I'm sorry, this is repeated, but you did understand there may be a self-defense claim at the time.
Yes,
Okay.
ma'am, that's accurate.
So what was the defendant wearing?
Like if I remember correctly, it was like a I don't know what you call it. I guess like a crop top, tube top, something like that, almost a sports bra kind of thing, and a pair of shorts, if I remember correctly.
Okay, so tube top sport bra kind of thing. Was
There was some midriff that was visible.
exposed?
He can be
exposed.
forgiven
Okay.
for not understanding modern women's
said you
fashion.
looked at her
It can get
clothes.
confusing.
I did.
And you didn't see anything torn or disheveled?
No, ma'am, I didn't.
Okay. And when you looked at her, did you see any injuries?
I did not.
Did you look specifically for injuries?
I was paying attention as we were standing there in the lighting out in front of the office, and then on the way up to the interview room. And as we walked her into the interview room, I was paying attention to that. Yes.
Did you see her face clearly?
Yes.
Did you notice any injury to her face?
No, ma'am.
Did you speak with her attorneys about the need for documenting these injuries
Yes.
or lack of injuries?
Yes, ma'am, we did.
Okay. And that's when you got the search warrant, correct?
It is.
And did you have an opinion about what you should photograph?
So my initial opinion was to photograph everything to make sure that we did a thorough and accurate job in documenting any injuries or marks that may be present. And we actually even put it to her attorneys. And I asked them, I said, if you would mind, go talk to your client and try to help us determine if there are any areas of injury or any areas, because we're going to do DNA swabs of the skin as well, to try to pick up any foreign DNA.
Very
foreign
true,
to her.
whoever.
And
Any response, Your Honor, I think we're heading into a dangerous area.
Yeah, I don't know if you're going to start talking about attorney-client privilege information or,
No,
okay.
no, I just wanted to get across that this witness asked the attorneys, where should I photograph, and then what the response was. And that's
Okay.
why.
All right, I'll overrule.
So you asked, should I pay attention
right.
to any areas?
Yes.
And go talk to your client and let me know.
Yes.
And they came back and said what?
Arms, legs, neck, and hands, I do believe was the
Okay.
final.
Arms, legs, neck, hand. Did they ever mention, or did anybody ever mention to you eye or face?
No, ma'am.
Did anyone ever mention to you midsection?
No, ma'am.
Did you ultimately arrest her that day?
No, ma'am.
Why not?
Because she had made that claim of self-defense, we wanted to make sure we conducted an accurate and thorough investigation. There was obviously a lot going on here with her past history, and we wanted to make sure that we did a thorough job.
Okay. So you said with her past history, so at least you were somewhat aware of some previous reports.
Yes, ma'am. There were some reports that were in the Manatee County Sheriff's Office computer records database that we were able to view.
Okay. And did you ultimately get another search warrant to take pictures of the defendant 3 days later?
We did.
And why did you do that?
Well, sometimes with injuries, they don't readily show up right away.
Okay,
Bruising
there you
sometimes
go.
doesn't come up initially. So we wanted to make sure that we did our due diligence again and check 3 days later, giving those injuries time to appear.
Okay. And have you
Legal
seen those
Vices, thank you
photos?
so much
I
for
have.
the super chat.
Do you recall how many photos were taken?
Of her in total,
Yes. Let me be more specific. So the first day and then 3 days later, there was more taken. So together, about how much were
100 or so,
Okay.
something like that.
So a lot of pictures.
There were a lot, yes.
And did you at any time, either at this first meeting in the sheriff's office or after the fact, see anything on the defendant that appeared to be an injury?
There was a small scratch. I believe it was on her side. But that actually came up during an interview that we did later on, and it was very minor.
Okay. As part of the investigation, was Doug Benefield's phone taken into evidence?
It was.
And was that phone searched or downloaded to gather the information?
It was. It was taken to our technical services unit, and they did an analysis on the phone.
So you don't do that?
No, ma'am.
Okay. So once the information is downloaded from a phone, is it in some sort of a format that you can read it and search it?
They do use certain programs that allow you to search through and help organize what you're downloading. I don't know the exact ins and outs of it, but I mean, I'm capable of using the program and reading through it, but
Okay.
I don't know the technical aspects of it.
Did you review certain information, some information from his phone?
Yes, ma'am.
Okay. And did you find anything about a U-Haul on his phone?
Yes, ma'am. There was a confirmation email that a U-Haul was supposed to be picked up locally. Then I believe it was supposed to be dropped off in the Bowie, is it Maryland area?
Okay. And were you able to examine his searches on his phone?
Yes.
And did you find anything interesting about his searches?
Yeah. So during one of the searches was actually, it looks like he was looking for a roommate. Like he was looking for a place to move into. It was like roommate finder or something along those lines. But in the Bowie, Maryland area.
And why did that seem of importance to you?
Well, some of the information that we had received was that everybody believed he was moving in
Okay.
with them. And obviously this kind of contradicted that.
Okay. Moving in with them, meaning Ashley
And
and,
her mother
Her
and
mother.
their child.
okay, in Maryland.
Correct.
I am going to talk to you about State Exhibit 45, and I know there may be objections to this. These are the text messages. There is a stipulation, which I think is number three, that this does not need any further authentication. But I don't know if the defense has a further objection.
That's correct, Your Honor. We stipulate that it's authenticated. However, we still preserve any appropriate objections, one of which includes hearsay and two relevancy.
And Judge, generally my response is that these are text message exchanges between the defendant and the victim for the 7 days right up to an hour before he's murdered. While there may not be anything, explosive on these text messages, that is the reason I'm putting it in, is that there wasn't any fighting going on. There wasn't any.
Question, Your Honor?
No,
Yeah, I think she's just responding to the objection.
yes.
Whoops.
It is to show the nature of their relationship leading up to the incident.
He's
It's
assuming he's going to
expected,
lose on the
and
objection then.
because of what is written in the stand your ground motion, the state feels it's necessary to show the tenor of their relationship and how the relationship was at the time in question.
Right.
So.
I guess my first question is, I haven't seen the text. I don't know what's in the text. I wasn't provided a transcript or a printout of the text. So I don't even know what the subject
go
matter
over it.
is. I don't know how many there are.
Yeah, we were going to go through it, and the detective was going to help me read these.
Right. I don't know how to make a ruling when I haven't even seen them yet. Maybe they're hearsay, maybe they're not. Well, you've got defendant statements, at least for one side of it. So is the other side of the conversation being offered for the truth of those statements, which would
No.
then be hearsay, or is
No.
it just to show the natural flow of the conversation, the effect on the, I don't know.
Yeah, I do think, Your Honor, it has to be relevant to some fact in issue.
And then you got relevance, so
Yeah, and it is not.
And
I don't know how to make this decision without seeing them.
And I do
So just a quick point of clarification, especially for any newcomers that were not here in the morning session. So because this is in front of a judge, there's no jury in the courtroom. The types of evidence that can come into this hearing is going to be a bit more broad, if not for any other reason, for the fact that the judge has not, as he just said, he hasn't seen this evidence before. He's just as fresh as you or I are on this case. And so in order to make an evidentiary objection, he kind of has to know what they're talking about in order to properly make a decision on an objection. So, he's generally speaking, what was going on in the morning was he was much more open about like, okay, let's allow let's show the photo, ask the question, get the answer, and then I'll make a ruling on as to whether or not that is permissible at trial. And the reason why that's okay here as opposed to during trial is because, again, this is in front of a judge and not a jury. So we're not worried about the jury getting confused, getting spoiled in a certain way, because of the fact that there is evidence in front of them that they are then supposed to like magically ignore. A judge is much more able to determine what evidence he's supposed to ignore, what evidence he's supposed to pay attention to, because judges do this all the time. They're trained in this. So he's able to make these kinds of determinations. So that's what's going on here. We're probably going to see these text messages here between the two parties, between the defendant and the decedent. I guess that's what we'll do. And also before I move on, let's get some questions here. Colin Penn, is there some burden of proof from either side, or does the judge just gather info and decide to dismiss or not? So this is a motion that has been brought by the defense, but the burden rests on the state. The burden rests on the state to show that she is not entitled to this immunity. So in other words, the state has to show that she did not have a reasonable fear for her life in the moment that she shot her husband. So the burden is on them, but the burden is much lower than, well, I don't know about much lower, but it's lower than it is at trial. So at trial, the state has to prove their case beyond a reasonable doubt. In other words, if there's any amount of reasonable doubt as to whether or not she was acting in self-defense at trial, that is enough for her to win and for the state to lose. But at this hearing, they only need to show by clear and convincing evidence, which is below beyond a reasonable doubt, but above preponderance of the evidence. Preponderance of the evidence is the standard for civil cases, which is more likely than not that something happened, right? So it's 50% plus. You get the football just beyond, anywhere beyond the 50-yard line, and the plaintiff's side wins. So that's preponderance of the evidence. Clear and convincing is in between that one and beyond reasonable doubt. So that middle standard is what the state has to show in this hearing in order for them to win. In other words, in order for this case to proceed to trial. If not, if the state doesn't meet their burden here at the end of the second day of this hearing, we're in day one, then this case can get dismissed. But keep in mind, if there's any kind of a gray area, and so far to me personally, this is looking like a very gray case. If there's any amount of gray area here, the judge is going to be very reluctant to take this case away from a jury, especially when it comes to like a criminal case where we've got constitutional rights involved, although dismissing it would be favoring the defense in this case. So you're not worried about any constitutional rights of the state. You're worried about constitutional rights of the defendant. But generally speaking, judges don't like taking that decision away from the jury. They prefer for the jury to make those ultimate decisions in these kinds of cases. So if it's not a slam dunk for the defense, I say it's going to trial, or at least it is still going to trial after this hearing. Whether or not they negotiate some sort of a plea deal or something is up to the parties, obviously, and we don't know what could happen with that. Sarah, question and random: how do you check state Supreme Court docket / schedule, or are those typically not available? I've actually never checked a state Supreme Court docket, but I have checked an appellate court document. It can depend on the state, to be honest with you, because each state has their own docket system, their own court system. So, you go, Google literally that, like state Supreme Court, like whatever state, like state Supreme Court docket, and try to see if you can find a case. That's my best advice on that. Claude Simeon, why isn't the U-Haul question considered leading? They do allow some amount of leading here that is just to sort of like transition the witness. You can also have different standards in different courtrooms. Some courtrooms are a little bit more laxed on different styles than others. So it could be that this courtroom is just they allow a certain amount of it, and then they're like, okay, like you are really spoon feeding this witness here. Yeah. Okay. Now let's get back to this.
I do have some further argument depending on what the actual objection is and what the response is.
So what I'm thinking is going to happen is that we're going to keep going pursuant to, or I'm sorry, subject to your objections, but I got to see them to even have an idea how to rule.
I understand. So, Judge, we can continue.
I left my quarter upstairs.
We can continue on as the court suggested earlier. I'm confident the court will rule.
All right. Thank you, sir. So this is subject to any objections.
Okay. And if we could just dim the lights a little bit right in front, just the ones in front of the screen would be
The
okay.
mood lighting.
And the state would enter into evidence states exhibit 45. I don't know that I actually did it after the objection. Or would you like me to wait?
Yeah, we're going to
Okay.
have to wait on all of it.
Okay. Okay.
Now, ultimately, even if I don't allow them, I imagine you're going to want to put them in
Right.
the record for your proffer and appellate purposes. But for
Right.
right now, I'm delaying ruling on all that.
Okay. Now, you have a pointer right in front of you.
Yes, ma'am.
Yeah, if you wouldn't mind. It's really hard to see on this screen, so I'm going to zoom in a little bit. Let me go all the way to the top. What are we looking at here? If you could just tell us what information is in this.
So this appears to be a timeline of text messages. Down here, it's telling what type, because there are different types of messages, instant messages, and depending if you have an iPhone, it might be an iMessage or an SMS. Over here shows the direction of the call or text message, whether it's an outgoing or it's an incoming. This would be the date that it was sent, and sent, and this would be the sent or received, I should say. Then this would also be the date and time. Then obviously direction from and to, and then the owner's information of each phone.
So are you aware of the reports that came into the sheriff's office? We heard testimony earlier about it from Stephanie Murphy, that there were at least 5 abuse complaints against Doug Benefield, saying that he was abusing the dog.
There were several, yes, ma'am.
Okay. And were all of those complaints before this date of 9/20/20?
Yes, ma'am, I do believe so.
So I would like for you to just, I'm going to make it a little bit bigger. If I'm just going to have you go through some of these so we can get sort of the tenor of what's going on here. So the ones in light blue are from who?
Okay, so the ones in light blue are from Doug Benefield,
And two,
and they would be to Miss Ashley Benefield.
and the orange.
And the orange are from Ashley to Doug.
Yeah, it might be better, if you look up here, you might be able, the video is horrible. Okay, so the first instant message is 9/20/20 at what time in the morning?
9/20/20 at 8:20 a.m.
Okay, and now it looks like there may be not a message necessarily, but an attachment.
Correct.
Okay, so Now, you've seen this before. So do some of these attachments work and some do not?
Some, yes, ma'am. Some of them do, some of them don't.
Okay. Do you know why that is?
I think because some of them are actually based on the internet, not something that's downloaded. So sometimes if you're not connected, the link won't work and
Okay.
various other reasons.
So this is the first one. And what is this?
Looks like a Bible verse.
Okay. And that was from Doug to Ashley, correct?
Yes, ma'am.
Okay. And then if you could just go through the next few lines.
Okay. On 9/20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with iPhones now, they really have this thing going where you can actually laugh at an image or love an image, or you can do different reactions essentially. So as far as I'm aware, that's what we're actually when it says loved an image. I think it's her reaction to that.
Okay.
Most recent text message. 10:36 and 36 seconds. So 5 seconds later, she sends a message, good morning.
Okay. And then he says,
He replies with good morning.
and then within an hour after that, there is what looks to be an attachment. Is that one that you're able to open?
I'm not sure if that is or not. I don't think it doesn't have the line under it. So I'm not sure if we're able to open that one or not.
Okay. So then the next text message is from,
This one's going to be from Doug to Ashley. It says, run, baby, run.
and if you could just continue down the line.
Sure. Then Ashley sends a message, laughed at a movie. Ashley sends some smiley face emojis. That's what they look like. Doug replies, ready to rock and roll, laugh out loud, question mark. That was at 12:20. At 12:31.
God help me if my text messages ever have to be read like this, because I use emojis, I use emoticons, just having to like translate all of that for a judge or for a jury. Good Lord.
She replies, give me a few, LOL, trying to round up the cats. It's like trying to teach ballet to squirrels.
Okay, so I'm just going to scroll up. What's the next entry?
So within, looks like within seconds, he responds, ha, that's funny. Give me a few, LOL. He's basically saying he liked this comment. So essentially, like I said, it's a reaction to the comment that was given.
Okay. And then he says, or the next entry is her.
Shireen, yes.
What
Yes.
is
This
it?
is the day of the
So
murder.
1:06 p.m. It says OMG or oh my God, I'm exhausted, LOL. You can come over now.
Okay.
Sorry.
And at this time, it's your understanding they were living in separate houses, correct?
Yes, ma'am. He had an apartment down the road. I believe it was called the Green.
Okay.
And then she was in a subdivision.
So this here is Ashley telling him you can come over.
Yes.
And he says,
Sorry. He replies, ha, need to video the rodeo. Okay, headed that way.
okay.
That's at 1:08 p.m.
So yeah, there's been some questions in the chat about the timing of these text messages. These are in the hours leading up to his death. So these are definitely, to say that they are flirty, maybe. Yeah, I could see that. Lighthearted for sure. 100%. Doesn't seem to be any sign of conflict. That could have changed, obviously, at the time that they were there in person. But at this point, there's nothing obvious here showing that there was some kind of angst or conflict between them. Also, Jessica B, member for 12 months. Yay, 1 year. So glad to be part of the club. Jessica B, thank you so much for being a member of Bike Club for 1 year. 1 whole year, you have reached taco status. That's awesome. I love it. I love it. Thank you so much for being a supporter of the channel, and thank you for joining us today.
And then she likes a comment, but then at 1:20, what does he say?
So at 1:20, I'm walking around to back.
And she says,
I can let you in the front or whichever. He said, okay, front's good. Then she gave him a little thumbs up.
okay, so that entry was at 1:22 p.m. The next entry is several hours later at 5:37 p.m., which appears to be from Doug. What does it say?
Me and XS boxes arrived.
All right. And Ashley's response?
Is LOL. Then it looks like at 6:40, Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real.
Second word.
Real.
You're not supposed to use one of the words in the clue
Working mother.
or in the
Not a
answer.
working mother.
Working mother, not a working mother.
Not a working mother. I live in a
Slum. Oh no, it's running out of time. House. Real house. White. Oh, the housewives of. Oh, real house. Oh.
Oh, so he was the one to guess it. Okay.
Person on the left, that's Ashley, correct?
That's correct.
And then on the right, do you know who that person is?
That's her mother.
Okay. Then at the next entry is about 40 minutes after that one is what?
Let's see. We have, was there a response to that? I'm sorry.
I'm sorry. It looks to be a call log phone call.
Yeah.
Yeah.
So that looks, okay. So yeah. A call log, sorry. Incoming. It looks like there's about a 13-second call
From Ashley.
From Ashley
Okay.
to Doug.
And then the next entry.
Okay, so forgive me. Looking at these dates here, so he died. He was killed on September 27th. I'm seeing September 20th on some of these. So these might be not in the hours leading up to, but right now we're in the time zone of days before his death. So that video that we just saw was from, it looked like probably from an app version of, or a different version of a game called Heads Up, where you put your phone on your forehead and everyone else can see the answer that you're supposed to get, and they give you clues, and then you're supposed to guess it, and then you can either, I think putting up is to skip to the next one, putting down is to get you got the answer right, and it's like you're supposed to get a certain number in like a minute or something like that. Anyway, so that's what that game was for anybody that is a little confused about what that was. It's a really fun game. If you're at an amusement park, for example, with friends and waiting in long lines, it's a really fun way to pass the time. I've done it many times with friends. So that's what that was. Also, Shireen, thank you so much for the member chat. Member for 9 months. I'm a bit behind a year, LOL, but not too far. Not too far. Mountain Princess 207, not a taco yet. Congratulations, Jessica Beeb. Also member for 7 months. Wonderful. Love to have you guys here, and thank you so much for joining us today. All right, back to these text messages. Oh, and also, yes, questions here in the chat. Mountain Princess 207, who are those people walking in? Can anyone just come in and say hi? Yes. You have to go through security at any courthouse. It's just metal detectors, but the public is allowed to be there to view these proceedings. These are public proceedings. It's a way that we are able to watch our judicial system in action, and it's part of our First Amendment rights. Same reason why we're able to have cameras in the courtroom for a lot of these. There's always an argument, or not always, but there's an argument in a lot of these courtrooms, a lot of these cases. But in Florida in particular, they are very open about having people come into the courtroom. So yeah, that's just members of the public, or maybe people that are supporting one side or another, or maybe part of the media. Who knows? Sammy279, why did they live apart? They were, ever since they got married and found out that she was pregnant, which was very quickly into their marriage, which was very quickly into their knowing each other. They met, and then 13 days later they were married, like not engaged, married 13 days after having met one another. And he had just been widowed like 9 months prior. His wife died of a heart condition. So very, 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 very fast relationship. And then she got pregnant very quickly. But ever since that moment that she found out that she was pregnant, apparently, which was apparently very intentional because he had a vasectomy before. So they had to have a whole procedure to remove the vasectomy to have a child. So it wasn't an oopsie. This was very much planned to have a kid. But as soon as she became pregnant, she started making all these accusations against him, allegations about him poisoning her with heavy metals. Whether or not these things are true, I don't know. Like, to me, it seems like these are just kind of a little Looney Tunes, a little bit, to me personally, the allegations during their pregnancy or whatever. I think particularly because of the fact that like heavy metals are something that it would come up at a pregnancy checkup, right? When you're pregnant, you've got all kinds of doctor's appointments that you have to go to track the progress. And it's like it's very sensitive. I mean, any number of things, like you can't even have more than 200 milligrams of caffeine in a day. No alcohol. Like there's so many things that you have to give up in pregnancy, just to maintain the health, of the baby. And so if she's being poisoned by him, I feel like that would be something that would be caught by the doctor. So I'm really curious to hear about her medical records if they exist. Anyway, so why did they live apart? They were kind of almost like on again, off again, very, very volatile relationship. That's, I guess, the TLDR of it. Okay.
Next entry is from Doug to Ashley. It's 9/20 of 2020 at 8:58 p.m. And it says, "Good night, sweet theta waves. I'll be done by 1 tomorrow and plan on joining the party."
And she does what?
She loved the message at 9:22 p.m.
And then said,
Then good night. I'm sorry. Good night, huh? You sure want to come hang out at the slum? Or are you sure you want to come and hang out in the slum? So basically indicating what they were joking about in the video.
on the video. Okay. And his response?
Yep, be smashing at the slum.
Okay. Then skip down. The next one is that she liked that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21. So the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. We'll look at the attachment. And for the record, what is this?
It's another Bible verse.
Okay. And what's the next entry?
The next thing I see is, at 9:55 a.m., Ashley loved an image. Then she says, "Good morning."
Okay. And what does he say?
Doug replies at 9:56, "Good morning." And there's some little emojis behind it here. Then later at 12:46 p.m., headed that way in about 30 minutes.
Okay. And her response?
Her response, that's at 1:09. Oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now, not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway.
And his response?
So his response at 1:13. Oh, nice, a little breezy, which helps. Getting an early start can finish up early to come over and be with y'all and play with Emerson, free y'all up some. Just ping when good to head over.
And she likes that.
And she likes that at, 1:51.
And says?
Then at 1:51, a few seconds later, will do.
And then she also asks him?
2:47. Want to grab a can opener at Publix on your way over, LOL. I, of course, packed the one that we had.
Okay. So I'm going to run a little ahead. So this is the next day. If you could read that, what's at the top, that date.
All right. So we have an outgoing from Doug to Ashley on 9/22 of 2020 at 4:11 a.m. And it looks like it was a an attachment that was sent.
Okay, and we'll look at that. And for the record, if you could say what that is.
It's another Bible verse
From Doug.
from
Right.
Doug to Ashley. Yes.
And then he says,
Sorry. Then he says, good morning. Hope you slept okay.
and her response.
Looks like she loved the image and then replied with good morning.
I'm going to scroll up. How about later on that day at like 1:36, which is the top entry, and
Okay.
he says to her,
So Doug sends Ashley a message. Can you think of anything we need at Lowe's or anywhere?
and the
So-
next,
After that, at 1:42 p.m., it looks like Ashley reaches out to Doug via phone because there's a 48-second call.
okay, so it's a phone call.
Correct.
And then the next entry,
The next entry is at 3:23 p.m. and that's from Doug to Ashley. Headed that way in a few. I'd nothing need.
okay. And I'm going to scroll up. And then I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So looks like an image, or I'm sorry, some kind of an attachment sent from Doug to Ashley at 9:27.
Okay, and we'll look at that. And for the record, what is that?
It's a picture of Ashley and her daughter on the beach.
And the next entry is right after that,
Yes, ma'am. It's at 9:28 p.m.
and it also has an attachment.
It does.
Okay, and I'll open the attachment. What are we looking at, just for the record?
Again, it appears to be Ashley and her daughter at the beach.
So Doug sent these to her.
Correct.
I want to go to the next yellow square there. What, is that the same evening?
Yes, so 9:22 at 9:30 p.m. Another attachment is sent.
And this is what?
This appears to be their daughter at the beach, and I believe that actually can't see who that is there in the background very well.
So I think at trial, most of this is not going to be admissible because it's just like, it's definitely getting very tedious. What does this have to do with anything? It's like more than what is necessary to paint a picture of like, okay, there were no conflicts in the days or hours leading up to this incident. But this is not trial. This is, this hearing on the stand your ground motion or stand your ground issue. So yeah. All right.
Not very well.
Okay.
But it appears to be the same location.
Okay. So then I'm going to scroll down until we get to the next day, 9:23 of 20 at 6:47 a.m.
I'm going to
What's that
increase the
entry?
speed a little bit for this part.
So that is a message from Doug
Just a little
to
bit.
Ashley, and it
1.25.
appears to be another attachment sent at 6:47 a.m.
Okay. And the attachment again.
Is another Bible verse.
And then after that, he says,
So at 9:23, he says good morning. And at 9:28, he replies again and says, got email from Stephanie after she talked to Faith. Since order to mediate, we meet for 1 hour tomorrow to stop court next week. You dismiss injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs order for a report. As soon as she signs order, we file dismissal and we're done.
and what else did he say?
At 9:30, and we have joint session with Dr. Q Friday to wrap up our adventure in Florida and leave with understanding of double knots and red-blue inversion.
And the next couple of entries.
9:49 a.m., she loved an image. Then at 9:49, looks like 10 seconds later, good morning. Doug then actually, it says emphasized on good morning, so her response. Then Ashley sends another at 9:50. Okay, I'll reach out to Faith to follow up on all of the above with a thumbs up.
Okay. And then he likes that.
Yes, ma'am. So at 9:50, he likes that. At 9:51, and we're all done. Or I'm sorry, and we're done.
Okay.
At 9:52, Doug sends another message, and all in first 10 days of Jewish New Year, LOL.
Okay. So
And then she likes that comment.
we're going to scroll down to the 9:23 or 9:23 at 10:13 a.m. from Doug. What does that say?
9:23, 10:13 a.m. Doug to Ashley. So perfect outside.
And she loves a previous comment, but what is the next comment underneath of that?
So her comment at 10:14 a.m. says, "Oh yay, we should do Selby today."
Okay. And his response?
His response is at 10:14, "Oh yes." Then he responds, "Yum."
Okay. Then I'll scroll through some of this. The message at the top from 11:39 a.m. Who's that from?
So that's from Doug to Ashley. And the text is, "Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do." Just a one pager.
And next?
Then he sends another text, "What time thinking Selby?"
And then she likes the first comment. And then what was her response to Selby?
So her response at 11:44 was maybe 1:30ish. "I'll text you when we are heading that way."
And then he says, let me scroll up here. There.
So at 11:44, he replies, "Okay, I can come pick you up too." 12:12, he again sends a message.
Proven correct based upon your oath.
Based
Whoa.
upon everything I know to the best of my knowledge.
What the heck?
Would you tell Judge White whether or not?
Hang on. Oh, this forced us to live. One second here. Well, okay. I mean, I feel like we still need to see these text messages though.
So I'm going to run.
Okay.
And then I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So looks like an image, or I'm sorry, some kind of an attachment sent from Doug to Ashley at 9:27.
Okay, and we'll look at that. And for the record, what is
Okay. Okay. So yeah, we can skip ahead of
At
that.
9:52, Doug sends another message, and all in.
Okay.
I'm just gonna
So
scroll up here. So the next entry I want you to read is from 5:53:38 on the same day.
Okay.
And what does he say?
So it's an outgoing message from Doug to Ashley, 5:53. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out.
Her response.
Her response at 7:02 is, "Ha, okay, thumbs up."
And his response.
And his response at 7:05, "Thumbs up, prefer tonight, maybe run over Pandera or in morning or AM, sorry."
And she says.
At 7:24, she says, "Sure, can do Panera tonight."
And the next entry.
Next entry is outgoing from Ashley to Doug at 7:24. It says 8 ?
Okay. And he
Then-
sends a thumbs up.
Yeah, 7:27, he sends a thumbs up.
Okay. And then they're telling each other good night. Good night, sweet dreams.
Yes.
And the next
we're on
day
a
in the
1.5.
morning,
So
7:00. Who is that from Doug?
yes, it is. It's from Doug to Ashley on 9/24/2020 at 7 a.m. And it's another attachment,
Okay. And for the record, what is that?
another Bible verse.
He liked his Bible
Scroll
verses, it
through.
seems.
This entry here is 9:24 at 10:09 a.m.
Okay.
Can you read what that says?
9:24 at 10:09 a.m. It's from Ashley to Doug. It says, "Quick and easy, LOL."
And his response.
His response, he emphasized quick and easy, LOL. Then at 10:26, "So nice to experience quick and easy, finally, LOL."
Okay, so I'm going to scroll again. On the same day, 12:50 p.m., can you read this?
Okay. So yeah, 9:24, 12:50. This is from Doug to Ashley. It says, "Just to ponder while I finish up, thinking about getting all the cars up there. And I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul more flexibility, like taking things straight to storage."
And she says.
Her reply at 1:27 is, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep, and I'll drive with Emerson in my car."
Okay. I'm scrolling up again for the record. And the next day, 9:25. This is 2 days before the murder.
So 9:25 at 5:45 a.m., there's a message from Doug to Ashley, and it's another attachment.
And what is this?
It's another Bible verse.
What is the next
Yeah, I
entry?
think he just
So
liked
the next
sending her
entry is
Bible
9/25,
verses
2020 at 6:03 a.m. It's
for
from
whatever
Doug to Ashley,
reason.
and it appears to be another attachment.
And if you could read what this says. It's
Sure.
an attachment, but what does it say?
Live a life filled with love.
And he says, good morning.
Yeah, so at 9:26 a.m., he sends her a message saying good morning.
Right. And then what is the next thing he says?
The next thing he says is at 9:27 a.m., and it says Dr. Q is at 10:30. Do you want a chai?
Okay. And they go on talking about the tea. I'm scrolling.
Spill the tea.
This is one day before. This is 9/26 of 20 at 6:43 a.m. What is this?
So this is a message again from Doug to Ashley, and it appears to be an attachment.
And what is that?
Another Bible verse.
And he says,
And he then sends her a message, good morning, at 9:40 a.m.
and she responds,
9:54, she loved the image. Then at 9:54 and 17 seconds, good morning.
okay. And then I'll scroll a little bit. So this is 9/26/20 at 12:27 in the afternoon from Ashley. What does she say?
So Ashley sends a message to Doug, want to come pick me up and we can go get the truck.
And he says,
He replies, sure, heading that way. Then later, let's see, at 12:41, I be here.
and,
Then at 9:04, good night, sweet dreams.
okay. And she likes the image or loves the image. And
Yes.
says good night.
Love the image, and then replies good night at 9:23.
Okay. So the next day, 9/27, this entry's at 6:42 a.m. What is this?
So this is another message from Doug to Ashley at 6:42, and it's another attachment.
And this must be one that we can't open. So he says after the attachment,
So at 10:02, he sends a good morning, some little emojis.
and she loves the image, and then
Love the image at 10:06. So then 10:06 and 10 seconds replies with good morning.
okay. So there are several short messages, and then at 1:03 p.m., this message appears to be from Doug. What's he say?
So Doug sends a message to Ashley, what y'all working on?
And she responds.
She replies, last cram, LOL, using the big boxes and getting the last loose stuff packed up and ready. That was at 1:15.
And then she also says,
She also says, how's it going over there? Making progress.
and his response,
His response at 1:18, loose stuff should be a chapter in our book, LOL. Got everything out and in garage, ready to throw on truck except couch, aka bed, pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go.
and he says after
Then
that.
at 1:19, I'll come there and drop him off at 3.
And then she laughed at the message
Correct.
from him. She also liked the message, I'll come there after 3.
Yep.
And then what'd she say?
Then at 1:20 p.m., great, could you run by Lowe's before you come over? Grab a few more large and mediums.
And he says,
Sure, I need a few too.
she likes that. And then she says,
She likes that. And then at 2:36, just to be safe, let's do 10 of each just for the last bits here.
and he likes that.
He likes that. And at 2:36, he also replies, okay, let me know. I'm sorry. Okay, let me know anything else if think of.
And then she says,
Tape. At 2:50, she replied tape, but then also LOL.
and he responds,
At 2:50, he says, ha, okay. Then at 2:51, just finished the vet, headed to the spa, LOL.
and she laughs. And
Correct.
then the next entry,
At 3:45, he advises that he's headed there.
and she says,
She replies at 3:51, okay.
then he says,
At 3:54, I'm out here out front. Or I'm sorry, I'm here out front.
and her response,
Her response is at 3:55, okay, 1 minute.
okay. So he must have left at some point. This jumps 2 hours or an hour and a half. And the next entry is from Doug to Ashley and says what?
At 5:10 p.m., it says I'm about to head back.
Okay.
Then at 5:11, there's some kind of an attachment that's sent from
That we
Doug to
can't open.
Ashley.
And then at 5:11 p.m.,
At 5:11, Doug sends another message to Ashley. Everything and except couch and 10 medium boxes and 2 cab, LOL.
and she laughs at that.
And she laughs at that at 5:14. At 5:14, she then sends a message to Doug, ha, OMG.
And he says,
And at 5:32, he sends a message back, trucker on the way.
and what time was the 911 call again?
6:56,
Okay.
approximately.
All right, we are through the text messages.
When was Ashley arrested?
A little over a month after this occurred.
Okay. And why'd you wait so long?
We were trying to do an in-depth and thorough investigation, look at every aspect of what was going on. She made a claim of self-defense, and we wanted to make sure that we did everything possible to either prove or disprove that.
Okay. Was a booking photo taken of her at the time?
Yes, ma'am.
Okay. And what was the date? Do you recall?
Off the top of my head, Alex, it was a little over a month.
Okay. Beginning of November?
Yes.
Yes. Judge, this is the certificate of business records that the state did a notice of for the booking photo of Ms. Benefield.
Okay.
Object relevance.
Relevance is she looks exactly the same as she did in the other 2 sets of pictures that were taken.
Okay. Go ahead, sir.
Same objection.
I'll overrule.
I'm just going to put this up.
I don't know. What number is it?
Oh, I'm sorry. Statement entering into evidence states 46.
Subject to the objections that I've overruled, received.
Okay. I have no further questions. Thank you. Oh, Judge, I don't know that we ever got a ruling on 45, but we'll do an objection.
No, go ahead and do your cross, and then I'll hear all of the
Don't
argument.
let me forget, so
All
What
right.
was the number on that one?
45,
There we
the
go.
one that there's an objection?
Yes, 45. Okay.
All right, cross-examination. And before he starts,
Yeah.
actually, let me answer a few questions here. Carlos Eduardo, could someone explain what's the difference between a hearing and a trial? A trial is the ultimate venue where they are deciding the merits of the case. So in a criminal case, this is a criminal trial is, whatever the defendant has been charged with, they are going through all of the evidence, putting it in front of a jury, assuming that they've requested a jury. Most likely that's the case. But they are deciding the case finally on the merits as to whether or not to convict this person. That's a criminal case. The hearings will be held for any number of reasons, and sometimes they involve evidence, sometimes they don't. This is a hearing for a particular purpose, which is the question of whether or not this case should be dismissed before it even goes to trial. So it's in front of a judge as opposed to a jury. So that impacts the way that the evidence is kind of shown here. This is the type of hearing where evidence is actually shown. And the judge is the one who is going to ultimately weigh the evidence and make a legal determination. So the judge at trial, the judge is the trier of law, or the finder of law, and or trier of law, and the jury is the finder of fact or the trier of fact. So in other words, the jury is the body of people that are going to apply the facts to the law and determine the outcome of the case. But here there's a very specific legal question at play, which is whether or not she is entitled to have this case dismissed on an immunity ground that is stand your ground. It's self-defense. So she has said, that she was acting in self-defense. It was a reasonable belief. This is essentially an early chance for the defendant to have this case dismissed before it can go to trial. It's a mini trial in a lot of respects. We're getting to see this evidence, but we're getting to see probably more than what we would be able to see at the actual trial, because of the fact that there's no juror. There's a number of reasons why. So that's kind of the difference between this makes sense. And also, Dionysia Jaclo, I'm sorry if I'm mispronouncing your last name. Oh, my audio is cutting in and out. Dang it. Okay, hang on a sec. Come on now. It's choppy. Yeah, it says my internet is being a little busy. Okay, now it should be better. Okay. Okay. So, but I hope that was understandable what I was saying though about the difference between this hearing and a trial. Dionysia, hey everyone, missed the morning hearing. Question, what are her claims? So like I said before, she was claiming self-defense. Are you going to do a recap of video day 1? Because I'm super confused. I need one bite at a time. I'm not going to be doing a recap of this one, but I might at the end of the hearing, I might kind of recap the whole thing a little bit. But yeah, I hope that my explanation for Carlos was helpful for your questions too. Basically, she's charged with murdering her husband. They were separated at the time. They had a daughter who is now about 5 years old. And at the time, this was 2020, so the baby was around 2 years old. It was very, very, very messy relationship. And she was planning on moving to Maryland. He was also planning on moving to Maryland, but they were going to live separately. He also had a daughter from a previous marriage, who is now, I think, like 20. I think she was 15 at the time that this all happened. Or maybe 15 when they got married, when these two got married. Anyway, regardless, very, very messy relationship, very, very messy from the start, and very fast relationship at that as well. So if you need more details for context, there's more in the description of this video if you need to check that out. But I hope that was enough for you to be able to see that. Also, Kit Kat, thank you so much for gifting one Legal Bites membership. Maya Johnson, you've been gifted a membership by Kit Kat. Welcome back to Bite Club. I know you've been in it before. Happy to have you here. And thank you again, Kit Kat. Thank you. Very, very kind of you. Okay, let's get back to it. Because we've still got some hearing to get caught up on, but we're still at 1.5 because why not?
Now,
Yes, sir, absolutely.
Detective Warren, afternoon.
Good afternoon, sir.
So you testified that you were the lead on this case, and a couple of questions I think would be appropriate. The lead is kind of like the quarterback, no?
You could say that, I guess.
And the lead is also the one with the most comprehensive knowledge of the investigation and how it's shaping up and where it's going.
The lead is typically the person that has the overview in mind.
So that's a yes?
I'd say we work as a team, but sure, yes.
All right. And correct me if I'm wrong, but as the lead detective, you developed the theory of the case.
We all actually sit down and look at the evidence. Like I said, I don't go out to every scene. I go out to a lot of them, sure, but we have other individuals that do certain things. So it's really a group effort.
Well, let me ask you this. Do you remember sitting down for a deposition with me?
Yes.
And do you remember that was testimony under oath?
Yes.
Uh-oh.
You took the
Impeachment.
same oath for the deposition as you took this afternoon when you came in before Judge White, no?
Yes.
All right. Do you remember being asked the following question on page 9, paragraph 3? Okay, so as part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
My answer is still sure.
Okay. Now, you've told us on a couple of occasions that you wanted to make sure you did a thorough and comprehensive investigation.
Is that a question?
Yes, sir.
Yes.
All right. And that is because you certainly wouldn't want to jump to a conclusion on any case, much less a homicide accusation.
That's correct.
All right. And as a result of that, you spent quite some time after this incident running down leads and doing the investigation so you could make a fair and objective determination of what, if anything, was to be charged.
Correct.
And that included you investigating self-defense and things of that nature.
Absolutely.
All right. So I'd like to ask Jack if he would assist me on this. I'd like to put up on the screen, if I can now, the warrant that you authored.
And Judge, no, Jack, is there impeachment here?
Yeah, I mean, is this impeachment?
Yes, it's coming.
We need to ask him the question.
Hold on, as to which question so far, the thorough investigation, which,
The thoroughness of the investigation, its objectivity and fairness.
okay. I think there should be some specific questions to impeach with the document. I mean, is there going to be an inconsistent statement? Or?
Yes, sir. Yes, sir. If you'd give me a little leeway, Your Honor, I think I will satisfy the court that the questions that I'm about to direct are appropriate, and I will tie it up.
All right. I'm not quite sure because he hasn't answered any questions about the search warrant,
What is,
No, this is the arrest warrant.
the arrest warrant.
Yes, sir.
Okay.
I think the question needs to be a little more pointed. What exactly is this different than? What are you saying this is different?
Hold on,
from?
no crosstalk. Just go ahead, put your arguments on the record.
I would like to know what exact statement is being impeached and what he's using to do.
All right, thank you. Yeah, that's my question too. I'm not exactly sure what specifically you're impeaching from the testimony he's stated so far.
Okay. If the court will allow me to approach the witness,
Okay.
I think I can set the predicate.
All right.
Second, let me show you this document and ask you if you recognize.
Appears to be an arrest warrant. Yes, sir.
And whose arrest warrant is it?
Ashley Benefield.
And did you fill out and execute that arrest warrant?
I did.
All right. And that arrest warrant, correct me if I'm wrong, is a statement by you under oath that you took to a circuit court judge.
It is.
All right. And when we say a statement under oath, same oath again you took before you came into court this afternoon.
Yes.
And you represented to the judge that the facts stated in the attached affidavit to that arrest warrant were true and correct.
To the best of my knowledge.
By the way, how hilarious is it that we are at 1.5x speed and this defense attorney sounds like he's speaking at a normal pace? It sounds like he's like more at a talking pace because he just otherwise he kind of like works his way through a sentence. Okay.
To my knowledge.
Okay. Now, if I may, Your Honor, I'd like to put a select portion of that warrant up and ask him some questions.
Go ahead.
And I will
That's the one
demonstrate.
What's being impeached?
Well, I have to ask the question first.
Right. So generally the police report itself would not be admissible. So I need to know what the questions are, and then I'll need to see if that's materially different so that it could be used as a
Yes.
impeachment, as a prior inconsistent. I assume you're doing prior inconsistent statement.
Yes.
Okay.
And what I want to ask him about is first I want to establish what he said in the warrant. And then I'm going to show that a select portion of the warrant is in fact not accurate.
All right. Well, I think that's kind of putting the cart before the horse. I think we got to have the testimony here and whatever that testimony is, and then we'll figure out if there is a prior inconsistent statement.
Okay, I understand. So that is the warrant and attached affidavit that you actually served.
It appears to be,
All right. Now, everything that you had to say in there is true and correct based upon your oath.
based upon everything I know to the best of my knowledge.
Would you tell Judge White whether or not prior to you submitting this affidavit, you authored two prior affidavits, two versions?
What do you mean, two versions?
Did you author two separate and independent versions of that affidavit before you finally settled on the one that is before you?
I worked on the arrest warrant, so I don't think I ever set anything up. This was the first time.
No? Okay, so you know about Florida's public records law, do you?
Sure.
All right, and you know it applies to the Manatee County Sheriff's Office as well.
Absolutely.
All right, so let's see if you can identify this.
I could just see it. These are some of, Judge, first off, I would object. This is a conversation between me and the witness about drafting the warrant. It has nothing to do with what he submitted to the court. This is conversation between he and I about how it should be phrased. So I don't really understand what's being done right now.
Your Honor, these are two proposed prior warrants of the same version that was actually filed that are statements of this witness. And I'm going to show the court the difference between them and what was intentionally misrepresented and intentionally omitted.
Oh,
To the court?
To the court that signed the actual warrant. In other words, I'm going to show that this witness has materially made prior statements inconsistent with that warrant.
oh,
And that there were things intentionally omitted from that warrant
no.
that were previously included in the other warrant.
we have an
right, so-
allegation, a serious allegation against the
This is where I'm
cops.
getting confused. If we're going to impeach with a prior inconsistent statement, I don't think you can start that process with an out-of-court statement and then impeach with prior inconsistent statements. It's my understanding we've got the testimony here today, whatever that might be, and then there might be prior inconsistent statements, inconsistent omissions, commissions, who knows? But I'm not familiar with this. Do you have some cases about impeaching a witness who hasn't yet made any statements using three potentially disparate out-of-court statements?
Well, I think, Judge, if I can break it down for the court, I think we've had a statement by this witness on direct to the effect that this case took time because this detective wanted to be objective and fair and make certain that a proper investigation was done. And I am going to impeach that statement by showing that he knew otherwise and had already concluded otherwise, and that the statements delivered today in front of this court are false. And I can do that through his prior inconsistent statements.
Yeah,
Can I have them?
that should be a proper impeachment, actually.
I don't know.
I would just also ask for a copy for the state. These were never provided
So-
in discovery. I just took pictures of one of them on my phone so I can at least read it. The other one we've never seen except for briefly this morning.
Okay, so just to clarify for anyone that is confused, so what the defense is wanting to show is that the police here did not investigate properly. In fact, they manipulated some facts or some evidence for the arrest warrant and misrepresented this information to the court that signed the arrest warrant for the defendant to be arrested and charged and all that. So that's a serious allegation, obviously. But the judge here is saying, well, you can't just like bring in all of this like out of court statements out of nowhere, right? Like there's a certain process that has to happen. But what the defense said is, he's saying, look, on direct, he said, yeah, we had a full and fair investigation. We wanted to do things properly. He did say that, right? Because he was talking about how they took photos of her on the night of the shooting. Because I always want to try to use like tonally neutral language in these cases. I don't want to call it a murder. The prosecution's calling it a murder. I don't know if it's a murder or not. So anyway, the night of the shooting, they took photos of her. Then he said, well, we really wanted to make sure that this was a proper investigation. So 3 days later, we came back and took more photos. His statement saying we really wanted this to be a proper investigation is a statement that the defense now wants to impeach, which I think is a proper impeachment.
Are you asking for a Richardson hearing?
I'm just asking, no, I'm just asking if it's possible for defense counsel to provide us copies or something, so we know exactly what's going on. We may have just gotten.
Can I suggest maybe, Your Honor,
Yes.
the court excuse the witness?
Sure.
and we take-
Detective Warren,
Yes, sir.
the rule's been invoked, so I'm
Yes, sir.
going to have you step outside.
Sure.
Please don't discuss your testimony with anybody, your answers, the questions asked, anything like that.
Yes, sir. Thank you.
Because otherwise it's going to get really awkward because we're going to talk about you behind your back. So, you know, get out of here while we talk about you. Maybe in some not so great ways.
Can I assist the court by leading the court through what I intend to establish?
Well, let me read these first.
It's the highlighted portions, Your Honor, in particular, that I plan to go to
Highlighted portions of what?
the proposed affidavit.
They're not, first of all, Judge, we need to make clear that these are not sworn affidavits. These are emails. So these are not sworn to documents. It's just the proposed- This is the proposed body of the PC.
I understand.
Whisper, 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 whisper. Whisper, 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 whisper. Dang, this is some good lawyering here, by the way. I am impressed with. I know not everybody likes this defense attorney, but I'm impressed with his work. I'm impressed with the prosecutor here as well. So this is some good lawyering. This is not there are no Elaine moments here. Defense might actually pull this rabbit out of a hat. I don't know. We'll see. At the very least, they could change some of the narrative about this case before it goes to trial.
Okay.
I love seeing a
Ma'am?
trial with good lawyering. It's great. This is like
Yeah,
You
so-
want to
Here's what I would,
impeach the detective with the highlighted portions of what I'm holding in my hands.
yeah, let me walk the court through it if I may. If the court looks at the proposed warrant of November 2nd at 2:06 in the afternoon,
Yes.
the court will see in the highlighted portion on the second page that the detective says the day before the shooting, Barbara Russell, Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the second proposed warrant, which is approximately an hour and a half later on 11/2/20 at 3:37 p.m., instead of Barbara Russell, her name is now removed and she's no longer an identifiable witness. Now it says the day before a witness, and it says Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the actual warrant that is submitted on 11/4/20, it says, Judge White, the day before the shooting, a witness, no longer Barbara Russell, explained that Ashley Benefield was inadvertently scratched when someone, no longer Douglas Benefield, but someone walked by her carrying a box. This witness before the court, Your Honor, sought a waiver so that he could speak with Dr. Russell. He got the waiver and he spoke with Dr. Russell. And Dr. Russell told him, and he admitted in his deposition to me, that she told him that Douglas Benefield was increasingly rough and would body check Ashley Benefield with a box, that he would slam it against her, and that it happened on the day of the shooting. And what is in those affidavits, both the actual and the proposed, is not that at all. When a detective comes to the court with a proposed warrant, it's not unusual that the court might ask some questions. And in this instance, if the court saw in the affidavit that it was Douglas Benefield who slammed Ashley Benefield with a cardboard box, the court might ask, being a student street smart, a question such as, what was the relationship between these two? Are they siblings or are they husband and wife? And when told they are husband and wife, Your Honor might say, well, is there a history of domestic violence here? And if the answer to that was yes, then the court might say, could this be a self-defense situation? The point being that the detective might have left without that warrant being signed. I think this is clearly in contradiction to what he's testified to about a fair and objective investigation that went on for several weeks before he submits this actual warrant. So I propose to ask him about his actual warrant and then go back and go over the two proposed warrants to show what he left out and ask him why he left it out. And if he did not think that relevant to a judge that he was submitting the statement under oath to.
Ooh.
To prove or disprove what material fact? How's this material?
That this was anything but a fair investigation and a diligent investigation in direct contradiction to what he has told us here today. And just so the court knows, this is not my only point. I have coming behind it even stronger.
All right, final thoughts?
Judge, to be perfectly honest, I have no idea what we're talking about. The witness was not asked anything that was inconsistent with anything he said before. If the defense wants to try to disprove that it was a thorough and accurate investigation, then the defense can put on evidence in their own case. I don't think bringing in extrinsic evidence, I don't think the evidence is appropriate evidence to use for that purpose anyway. But even if it were allowed in, I don't know that you could do this extrinsic evidence at this point to impeach him for, I said I did a thorough job, but no, you didn't. I'm just a little confused by that. So I would object to any of this coming in at this moment. Sorry, I just don't know what rule of evidence we're proceeding under.
Goes directly to bias of this witness who testified on direct. I didn't ask the question. The prosecutor asked the question, why did it take so long for you to get this warrant? Because we wanted to do a fair and objective investigation. That was what he testified to. And I'm going to show with his own statements that that was not the case. It surely goes directly to this witness's bias and motive. And I have additional very strong evidence, Your Honor, to support that as well.
All right, well, whenever I start doing an analysis of these kind of arguments, what I want to hear is, well, what are you trying to do? Because that informs me to which folder to go to open up to see what's the predicate that needs to be laid and then what's the procedure for doing something. I don't see this as impeachment by prior inconsistent statement because I don't think, yes, he said I did a thorough job, but I don't think that is
fair
necessarily then opens the door to, well, why did you put a comma here and not here? Then I'm being a bit melodramatic on that point, but because as I look at some of the highlights on the papers you've handed up, I mean, it's really a simple matter of just reordering some of the words. Now on the issue of the Dr. Russell, I see where in the 2:06 p.m. email, Dr. Russell is mentioned.
Correct.
In the 3:37 email, Dr. Russell's name is now a witness.
Correct.
And I'm trying to look amongst all the talking at the actual arrest warrant that was submitted. It looks like it was attested to November 4th of 2020.
Yes.
I'm not seeing the incident with the.
I can show the court. I have it marked. Yeah.
Yes.
I think, Judge, what distinguishes it from something that's inadvertent clearly is not only is Douglas Benefield now removed from the actual warrant as being the one who scraped Ashley Benefield with the box, but now there is the statement that that whoever this person was inadvertently scratched her with the box. And that is in direct contradiction to what this witness was told prior to him filing that arrest warrant. He asked for a waiver, which was given to him so he could interview several psychologists. He went and interviewed Dr. Russell. He acknowledged in deposition to me that Dr. Russell told him it was Doug Benefield and that he was becoming increasingly objective on that date by slamming a cardboard box into Ashley Benefield as he passed her in the hallway. And it was on the day of the incident, not the day before.
Right. But that testimony itself, you're just introducing that's what he was told, not for the truth if that's what happened.
Correct.
Okay, because that would be how many layers of hearsay?
No, look, I'm trying to show what he knew because he's the one who filed the affidavit, Your Honor.
Yeah, so I'll allow it for the very limited purposes of the fact that if you think that this shows that, and you're going to link this up, that he didn't do a thorough investigation, okay, we'll see.
I will link it
but,
up.
I mean,
I'll link it up.
Yeah, I mean, I don't know about you guys, but when I write an order, there might be 4 versions of it as I go through.
Well, Judge, at the risk of embarrassing the court, as far as Your Honor's authorship of orders, I have never seen an order like the order that the court wrote for the motion to compel.
Well, that could be taken 2 ways.
I've never seen a better order or more thorough.
Enough of platitudes. All right.
I would just like to object to him using emails between he and I discussing probable cause as some form of, I don't understand.
Ms. O'Donnell, I'm not quite sure yet either,
Okay.
but we spent a lot of time on this.
Yes.
I want to keep plowing through. I think I'll be able to figure it out when we get to the end of this. I'm pretty sure I'll be able to figure it out and where this fits in, and I will put it in its proper place and give it its proper weight.
Thank you, Judge. And just for the record, I have no intention of involving Ms. O'Donnell in this. It's
Yeah,
going
if
to
you
be,
call her as a witness, we got a problem.
it's going to be limited strictly.
All right. You can.
Yeah, I can understand her feeling very awkward about it because these are conversations between her and the investigator.
Yes, I'm sorry. I apologize. Yes, sir.
Okay, so he's going to go in and try to impeach him to say that, look, you were not very thorough on this
I'll
investigation.
tell you what, though. Let's not plow this earth too many times. Let's plow it, make your points,
And move on.
get in and get out.
And I think you'll find I will do exactly that.
Yes, get in, get out, make your point.
All right, so go ahead and take your seat. You're still under oath?
Yes, sir.
As you're approaching your seat,
Detective,
you may
we've been
talk to me about
talking.
Your testimony or discuss anything with you?
We've
Yes,
been
sir.
talking
All
a
right, so
lot
have
of
seat.
trash about you.
For your purposes, from where you left off, I have overruled the state's objection. Mr. Taylor has some questions for you.
Sure.
Oh,
All right,
boy.
Detective Warren, I'm going to put your actual warrant up on the screen, the affidavit. You recognize it, no?
Yes, sir.
Okay. Are you able to see it?
It's a little blurry.
Okay.
Oh, Carol, thank you.
Let me give you this actual copy.
Okay.
So that'll assist you. Now, this was the affidavit that you took to the judge, correct?
Yes, sir.
All right. So I've highlighted on that affidavit in that particular paragraph that you see, and I have a couple of things boxed in red, correct?
Yes.
All right. I want to ask you about them. Does it say that upon further investigation, hold on a second.
So this is at 1.5x speed because we're catching up. We're
All right,
about
does it say,
12 or
Detective,
13 minutes
in
behind at this
the
point. We'll
third
get caught up
sentence
soon
of the
enough.
top paragraph, upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box.
So in the fourth sentence, I do see that it says that, yes.
All right, now I'm going to pass to you a document and ask you if you recognize it.
It appears to be an email from myself.
Don't tell me what it is. I'm just going to ask you some
Sure.
questions.
Okay.
Does that document contain a proposed affidavit that was written by you?
There is an attachment to it. I mean, I can't say indefinitely that's the same one that was sent with it, but there is an attachment to it.
All right. Now, that document was sent on November 2nd, 2020 at 2:06 p.m. in the afternoon, correct?
According to the email you provided me with, yes, sir.
All right. And if you would turn to the proposed affidavit that's attached to that document that I just handed you,
Okay.
not the actual warrant,
Yeah, correct.
the email of,
The alleged attachment, yes, sir.
yeah. All right. So if you would tell me, instead of it saying now, a witness explained, is in that proposed affidavit, does it say Barbara Russell?
Oh, I'm sorry. Yes. So on the second page, we conduct an interview with Barbara Russell.
Okay. Now, Barbara Russell, her name has been removed from the actual affidavit, has it not?
Yes.
All right. Does it also then say that Douglas Benefield scraped Ashley Benefield with a box?
It does.
Okay. And going back to your actual warrant, does it say Douglas Benefield in your actual warrant?
No, it says someone,
Someone.
which
Okay.
could mean Douglas Benefield.
All right. And does it also say in your actual warrant that that someone who scratched Ashley Benefield with a box did so inadvertently?
While walking by. Yes.
Now, do you remember, as part of your investigation, you obtained a waiver for you to be able to go speak with Dr. Russell?
That's correct.
And that included also a waiver for Dr. Quintal.
Yes.
All right. Is it not a fact that you admitted to me that in your conversation with Dr. Russell, before you filed this actual affidavit to your warrant, that she told you that Douglas Benefield had become increasingly rough and would body check Ashley Benefield with a box?
I think those were your words.
And did you not agree to them?
I'd have to go back and listen to the interview. I apologize, sir.
Did you prepare to come here today to testify?
I did, sir.
You chose not to listen to it?
Objection.
Sustained.
Yeah, he's getting a little feisty with the witness here.
Do you recall being asked the following question on page 23, line 14? This is your deposition of May 16th, correct?
I don't know. I don't copy it in front of me, sir.
May I approach the witness, Your Honor?
Yes.
May 16th of 23. Okay.
All right. You recall being asked the following question. All right. And does it say on there, starting on line 11, so she said, this is Dr. Russell. So she said he had become increasingly rough, like he'd pick up a box to move it, pass her in the hallway, body check her. Your answer, that's what it says. Do you want to see it?
No.
All right. Then the next question, all right, do you recall her making that statement to you? Your answer, vaguely. You recall that?
Yeah, but I still vaguely remember that.
Can I just ask for verification of what you were referring to, the first question? The first question was, you said this excerpt says, what was the excerpt that you were looking at?
That Dr. Russell had, may I respond?
Yeah, you're going to have to, because I don't know what we're talking about either.
The excerpt was that Dr. Russell had told the witness that Douglas Benefield had intentionally slammed the cardboard box.
And it's excerpt from what? Excerpted from
From Dr. Russell's statement that this witness took. I was questioning him about the statement that he took from Dr. Russell. And I asked him, is it not a fact that this is what Dr. Russell told you? And that was the answer that he gave.
And this is where I was concerned. We're now impeaching with a prior inconsistent statement,
Yeah.
conceivably. Statements that they were made in one version, but not the other version, and left out of another version, or
Right.
changed in another version. And you're impeaching with a statement from, an out-of-court statement from this witness received from a doctor who I haven't heard from, that was made to her, presumably by the defendant.
Yes.
No.
So we're just so far afield. And this is where I was saying, make your point and get out, because I've tried to give you that wide berth, but
I'm on my way out, Judge.
okay.
All right.
All right.
Yeah, it is getting a little bit, it's hard to say that he's really impeaching him, because it's like the statement that the defense attorney here is talking about is a statement that the defendant made to Dr. Russell, who we don't know. We haven't heard from this person. We don't know who he is. And then that Dr. Russell made, and this is a game of telephone, literally, made a statement to this witness about her allegation that Doug had body checked her. And then, there are earlier versions of the arrest warrant that have this detail in it, but then later they don't. It is starting to get a little bit. He made this inflammatory claim about, like, look, the cops are dirty cops. They're not investigating the way that they need to be investigating. But then his evidence behind him is a little bit less robust, it feels. So, okay. All right. You've got to make the arguments that you can make. You put your best foot forward, but woof.
All right. I get the point you're trying to make.
Yep.
The
Okay.
point is, this witness has made multiple prior different statements, spoke with the state, changed it again, left out some what you believe to be material details. I get it.
Okay.
The message is clearly received, if that's the point you're trying to make.
Thank you.
I just believe there's going to be numerous things like we're dealing with right now with this cross-examination.
Let's see how I do, Your Honor.
Okay.
All right. When you bring an arrest warrant to a judge, are you ever asked questions before it's signed?
Excuse me, what kind of questions are you referring to and by whom?
Have you ever been asked questions by a judge about a warrant that you have brought for signature?
Sir, I've submitted numerous warrants. Most of the time we don't talk to the judge.
You've never been questioned by a judge,
Most of the time we don't. Most of the time it's submitted via e-warrants, which is an electronic system.
and it's never happened to you, is your testimony.
Oh, I'm not going to say I've never talked to a judge. I just don't recall an incident off the top of my head.
All right. Let's talk about the wounds to Douglas Benefield and your perception of how they occurred. You stated, did you not, in your affidavit, that based upon the entrance wounds to Douglas Benefield, it does not appear that he was facing Ashley Benefield when she began shooting.
Objection.
Sustained.
Did you draw any conclusion as to whether or not Douglas Benefield was facing Ashley Benefield when he was shot?
Do you want me to read the warrant?
No.
No, so this is
Okay.
just testimony.
Just answer the question.
So yes, based on my observations and the work of the team that was assigned to work this case, it appeared that he was not facing her at that time.
And you know that the medical examiner said that he was.
I don't know what the medical examiner said, sir. I wasn't in here.
Oh, you've never seen the medical examiner's report?
Sustained.
I have seen the medical
No,
examiner's
no, no,
report.
I sustained it.
Sorry.
It's improper impeachment. To impeach this witness was the statement of an out-of-court statement of another witness.
Did you contact the medical examiner's office before you secured and drafted the final version of this warrant?
No, I did not. A detective would have been present at the autopsy, though.
Do you dispute now, as you sit here today, that Mr. Benefield was facing Ashley Benefield when he was shot?
Objection, relevance of his opinion.
Well, I think he's made the one conclusion. I think he could be asked, do you have the same conclusion today? So overruled.
Thank you.
I don't dispute anything the doctor said. He's the ultimate person that would give you that answer.
All right. Now, you also concluded that the wound to the right leg was from the outside of the leg to the inside. Is that correct?
Objection, relevance of his opinion.
Again, I don't recall ever hearing him testify to that fact. So I don't know where that's coming from. I have not heard this from his mouth.
Did you reach a conclusion as to the direction of the gunshot to the deceased's right leg?
Objection, relevance of his interpretation of the direction of that wound. The state is the one that filed the charge, not the detective. So
I appreciate it. Overruled. If you can answer.
Sure.
I'm sorry, can you repeat the question?
Did you reach a conclusion, Detective Warren, as to the gunshot wound to the deceased's right leg?
Okay.
Okay, yes, you
As
reached.
to the direction?
Yes,
So like I said, I would defer to the doctor, to be honest with you. I think he has the best opinion on that.
I understand that. I appreciate that, but I'm interested in what your conclusion was.
So based on my observations, I wasn't there when he was there and I never saw him in person, would be that the right side of his body was facing Mrs. Benefield.
That's not the question I asked you, Detective. Did you not understand it?
Apparently not. Can you repeat it, sir?
Okay.
Woo,
So my question
we're
to
getting
you is,
spicy.
Did you reach a conclusion as to the gunshot wound to Mr. Benefield's right leg?
Based on what I saw and everything at the scene, I believe that his right side was facing her. So that would have been what was struck first.
Did you state that the entry to the leg wound was on the outside of the knee and the exit was on the inside?
I could refer back to the warrant if you'd like, sir.
Please. If that helps refresh your recollection.
Sustained. Well, if he's refreshing recollection, that's a different issue.
Yes,
But
refer to your warrant, Detective, see if that refreshes your recollection.
I think we should probably slow this down to 1.25 just because of how spicy it's getting. So we're still faster than normal, but not quite 1.5x. It's folks are getting
So
Hey,
in my
this
affidavit,
back and forth is speeding up a
warrant.
little bit.
if one of the rounds entered the outside of the right leg and exited the inside of the right leg. That was based on what I was observing.
And as you sit here today, is that still your position that the entry wound was on the outside of the right knee and the exit wound was on the inside?
It's not what we heard from the medical examiner.
Based on my training experience, what I observed, sure. But like I said, I would always defer to the doctor. I would never argue with a medical expert.
Yeah, medical examiner said the opposite.
So I would assume then you would defer to the doctor as well as it relates to the proposed wound to the arm.
Absolutely.
All right. So you got wrong. One, whether or not Mr. Benefield was facing Ashley Benefield when he was shot, correct?
sustained and
All right. Your conclusion was inaccurate.
sustained.
All right, moving on. You told us that you observed Miss Benefield that night, and you did not see any signs of domestic violence, struggle, or things of that nature, such as torn clothing.
That's accurate.
Okay. And is that, in your experience, always the case with domestic disputes?
No, not always.
All right. And you're aware that the shirt that you observed on Miss Benefield that night, where it came from?
I'm sorry, which shirt are you referring to?
You said that you did not observe any torn clothing on Miss Benefield that night.
I did not.
Like her shirt was not torn, her shirt wasn't torn.
I didn't see anything, no.
Okay. Where did the shirt that you remarked that you didn't see torn come from? Do you know?
I have no idea where she purchased the shirt or where she got it, sir.
Isn't it a fact, Detective? Now, you're the lead detective, correct?
Sure.
That shirt was brought to her by another deputy while she was sitting in the squad car, was it not? That would be Deputy
I wasn't at the
Paul.
scene, sir.
But wouldn't that be something you'd be expected?
I don't know if it is or not. Let him finish the question.
Wouldn't that be something as the lead detective you would be expected to know before you make the statement that you didn't observe any torn clothing, which is inconsistent with domestic violence?
No, and I think if you actually play it back, I already testified to the fact that she was wearing a sports bra.
All
I
right.
did.
I want to ask you a couple of questions about the home. You drafted a search warrant for the house, correct?
That's accurate.
All right. And you drafted that search warrant pretty much immediately based on your experience of knowing that you wanted to get into the house to conduct the investigation.
I drafted that search warrant based on the other detectives on scene advising there was probable cause to assume that a potential homicide occurred inside. Yes, sir.
Okay, now.
Oh, he's got a lot of
I'm glad
attitude,
you
which is
referred
fine. There's
that
no
way,
jury.
Because isn't it a fact that that warrant that you were drafting less than 75 minutes after the shooting, isn't it a fact that you didn't describe it as a homicide, you described it as a murder? Did you not?
I'd have to look at the warrant again, but that's
I'll be
possible.
happy
Sure.
to show it to you.
Yeah,
Understand the difference.
so what's the relevance?
I think the relevance is to show that this detective had already reached a conclusion
Yeah.
that this was a crime rather than a homicide, despite his testimony that he wanted to do a fair and objective investigation over the course of an extended period of time, and that he was referring to it and calling it a murder within approximately 75 minutes following the incident.
All right.
He'd already made his mind up.
Detective Warren, can you step out in the hallway? It's easier if you step.
Ooh, we're going to talk some more about
The
you.
rules being invoked and discuss your testimony. Don't let anybody talk to you about your testimony.
Hey,
What
Kurt.
is love?
This
I'm having a
is
good day.
getting super spicy. Have you been following what's going on here with this witness?
I have not. No, I literally
This
just
is-
got back from the gym, and
this
boy,
is
are my
the
arms
lead-
tired.
Oh, good. This is the lead detective on the case, and
Right.
the defense attorney right
I
now
don't
is
I think I have the.
alleging all kinds
Search
of
unless it was committee
improprieties
attachments.
in this
I don't
investigation.
recall,
Basically saying you
seeing it.
made your conclusions early.
I'll give
You
the court a copy.
Well, let me ask you this.
you know, didn't follow
So
up on
the point
some
you're
things.
making
Like,
is
it's
that
crazy.
Instead of using the word homicide
Okay.
as the crime that's being investigated.
He's
the
making the
detective used
allegations.
murder.
I don't know that he's making
Yes,
all these
and
points
So
very
what
well.
statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime
Lost Planet
or
to
the
us,
evidence of
baby.
that
Lost
crime is
Planet.
gonna
Like
be
it's the
found
first time
within
we're
the
ever hearing
place
it.
to be searched.
Mhm.
Yes.
So a search warrant will list a crime or crimes that have alleged to have been committed. So what I'm saying is, what is your argument that he should have put as opposed
Homicide.
to murder with 78204?
Yes, sir.
Yeah.
As opposed to 78204?
My argument is that every single member of the Manatee County Sheriff's Office but him.
The word
described
warrant
this
is
as a
Latin.
homicide,
It
including
means
the medical
right.
examiner, rather than a murder. But that's not enough. This detective, in his deposition to me, believe it or not,
glad to help.
under oath, said and represented that every homicide is a murder, and anybody who shoots and kills somebody is a murderer. That is his perception of murder. As opposed to an objective evaluation, what I am tying in is that within 75 minutes after this incident occurred, this detective had already decided that my client had committed murder. That's what I want to bring out.
All right. I appreciate all that. I'm happy to receive that. I'm going to respectfully, as you said today several times, suggest that there is a much more direct route to get where you want to go. There's no jury here, so, impeach, but
Is the judge giving
Okay,
the
yeah,
answer
okay,
and
so
he's
I
not
think we
listening?
can
Is that
get
what's
there.
going on right now?
I think we can be a little bit more direct about it.
Yes,
Um,
I understand.
Seems like it.
I'll go
Because
right
when the
to it.
judge gives you
I
the
think,
answer,
you want to say, hey,
just do
you
that.
said murder in your
Right.
search warrant. Yes, I did.
Yep.
That was within 75 minutes of being called out. Yes, it was. And then you can make all those arguments you want to make about how that was biased and his mind was made
The
up.
judge is mostly
and it
just
was
annoyed that the
predisposed, how this was
time is
going to
being
go,
wasted.
And I'll receive all of that.
Understood.
Okay.
I respect that.
There was one other issue you were asking about.
Judge, before we move on from that, just so I can understand from defense counsel, is, because I'm looking at the actual search warrant and the only time it refers to murder is where it says the statute number. Is that the only instance in which he's referring, or is there some other? I couldn't find another one. I just want to make sure before we
I'm
continue that we
confused. I mean, he'd
understand.
have to
I assume
suspect them
that's
of some crime to get the
the
search
issue.
warrant, so I don't understand.
I just want to make sure.
I mean, he's
All
trying
right.
to make the point that like within 72 or 75 hours or 72 hours or
we're
whatever
in
of
Yes,
this
he's on the phone.
investigation that they had already determined that she was guilty of it, and that limits how they can properly investigate and all that kind of thing.
But wait a second.
Uh,
There's
Detective Warren,
is
take
there
your
any
seat back.
dispute that she did the thing?
Did anybody
I mean, the
discuss
dispute is the
No,
lawfulness
she
of the
she
thing.
admitted
With
she
you.
admitted
No,
to
sir. All right.
shooting him. She told the neighbor. She ran next door and told the neighbor.
So the cops
We
came
haven't
to
heard
the,
that
I
testimony yet, but this is
the
what I
cops came to
understand.
the
Sorry,
correct
75
conclusion.
minutes. Thank you guys. Thank you in the chat.
So-
apparently the
Detective,
cops
you
came to the correct
described
conclusion.
the
She did the thing. So what are we fighting
incident
over
that
right
you were
now?
investigating within 70.
If you had looked, if you had
minutes
kept your
of it
mind open,
happening
you would have
as-
found
as
other
a
leads
murder.
that would have pointed you to
In
other
the
suspects.
search
What are we
warrant?
talking
Okay.
about?
Yes.
So
Sure.
All right.
it
I think all
does.
of our search
It does
warrants
make a
actually are for the
difference.
same thing when
You
we're
did the
investigating
that
same-
it's
murders.
you
75
did the same
minutes as opposed to
thing for
75
two other
hours. That's
search warrants.
very
Yes,
fair.
Well,
That's where
apparently
we
in an
investigate
hour
some murders.
15, they were able to come to the right conclusion. So good on them.
Did you tell me under oath that every
I don't know if it's the right conclusion,
homicide
but
is a murder?
I believe I might have misspoke when I said that, but so basically, the intentional killing, unlawful and intentional killing of a human being is a murder. Yes.
Did you tell me, just to make sure that it wasn't a mistake, did you not tell me that anyone who kills is a murderer?
Well, there's differences in whether it being
Is the
justified or
answer to
not.
my question yes?
Objection, is this impeachment?
I'm going to sustain.
Thank you.
Again, I think
cares?
when we're impeaching with a prior inconsistent statement, we don't lead with the out-of-court statement that might be inconsistent. I would need to hear the
Doesn't
testimony
matter.
here today, what the answer is, and then I can determine if the prior statement is inconsistent. So I'll sustain.
Do you remember me asking you at the deposition the following question? On page 11, line 20, you could have a homicide that's,
Objection and proper impeachment.
I'm going to sustain. I need the answer. I need an answer here in open court, and then we
Okay.
can discuss whether that's a prior inconsistent statement.
are all homicides murders?
The unlawful killing of a human being is a murder. Yes, sir. There are some cases where it may be justified.
It may also be excusable.
Sure.
Is everybody then who kills a murderer?
And that's a matter of opinion, I guess. But I mean, by the definition, a
Excusable
murder is the
murder.
unlawful killing of a human being.
Is it your statement that anyone who kills is a murderer?
Objection, asked and answered.
Sustain.
yeah.
Would you be surprised to learn that you were the only one
Objection.
Let the question finish, please. Go
Yeah,
ahead.
he's
in
got to
the
finish his
Manatee
question.
County
What would an
Sheriff's Office
excusable murder look
throughout
like?
this case
What is that
who-
scenario?
Self-defense.
designated
No,
it
that's
as a
justification.
murder
He
as
said
opposed
excuse.
to a homicide?
Don't answer. Sustained.
Excuse would be like duress or something. Do they have duress for murder in Florida?
Another interview that you did was of Dr. Quintal. Was it not?
I did an interview with Dr. Quintal, yes.
And you conducted that interview pursuant to a waiver that was given to you by Ashley Benefield so that Dr. Quintal could share with you the health information that he derived from interviewing Ashley Benefield, correct?
Yes, sir. We were trying to gain an idea of what their relationship was like.
Did you learn during your interview with Dr. Quintal that Ashley Benefield was afraid of Douglas Benefield?
He may have made some statements indicating that she made some, or he had some feeling about that.
Did you learn that she was scared of violence from him?
I like I said, he said a lot of things. He also said he didn't understand why Douglas was with her.
Did you learn that Dr. Quintal told you that Douglas Benefield was a controller?
Objection, this is.
Sustained.
Not offered for the truth, Your Honor, offered for what this witness learned and knew during the course of his investigation.
And that's.
Well,
material.
what does that have to do with, I'm not understanding what the relevance of that is. That a doctor told this witness that the defendant said the victim was
Not the defendant,
controlling.
Your Honor, that Douglas Benefield, the victim,
Right,
was a controller.
right. But the doctor would have heard that from the defendant?
Yes,
All
but
right.
it's also the doctor's
Another game of
opinion.
telephone.
He was giving this detective his opinion of Douglas Benefield. And he was describing Douglas Benefield to this detective. And there's a reason why I'm asking. I'm going to follow up with a question.
It sounds like you're offering that for the truth.
Kind of
No, sir.
does.
I think you'll see why I want to show that this witness was aware of this.
Okay, I don't know, but we're going to see.
I will tie it up for the
Okay.
court very quickly. Do you recall Dr. Quintal telling you that he believed that Douglas Benefield was a fake who used God as a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
And you have that recording, do you not?
You should have it as well. Yes, sir.
Yeah. And do you recall Dr. Quintel telling you that Douglas Benefield?
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
That's what I want to
Next
know.
question.
Yeah.
If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
One of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield was violent?
We did searches based on what was available through the Manatee County Records database. And I believe we also got some information from Charleston or somewhere up, one of those places up there where there were some allegations, but that was it.
Do you remember me asking you this question at your deposition?
Well, I don't know if it is yet. It might be inconsistent with the statement that was just made about the investigation.
Objection,
but I don't know.
pointless,
Yeah, I
move
asked
to
the
excuse the
question.
witness.
Do you remember being asked the following question on page 84, line 16? When you investigate a case like this, you told me that you don't recall whether or not you did a background on Douglas Benefield himself. Your answer was, I don't recall doing it myself. No.
You're talking about a background, meaning the criminal history. I don't recall doing a criminal history on Douglas Benefield to see if he was a convicted felon, but a background check, it's actually listed, I believe, in some of these other reports where we looked up Manatee County computer records databases and pulled those reports.
So is it your position, Detective Warren, that only convicted felons can have violent backgrounds?
I've overruled.
Thank you.
If you repeat the question.
Is that what you're telling us?
Can you repeat the question?
Yes.
Thank
The
you.
question was, are you telling us that only convicted felons can have violent backgrounds?
No, but there is a difference between doing a computer record check through our personal database and doing a criminal history check through NCIC, FCIC.
So let me ask you the question again, but perhaps you didn't understand it.
Perhaps.
Did you ever do
Sustain.
Did you ever do a background investigation to determine what you've told us you would want to know, whether or not Douglas Benefield was prone to violence?
Like I told you, sir, we did searches to find out what information was available. You can change the definition of background check all you want to. Yes, we did our due diligence.
Have
This
you
line of
read,
questioning
by the
had
way,
so
have you
much
had an
potential at
opportunity
the
to read or
beginning.
discuss the stand your ground motion we filed with the prosecution?
I did, but it was months back, I'm sure.
There's a representation that Douglas Benefield grabbed Mrs. Benefield by the left hand to prevent her from leaving. Do you recall that?
No, not off the top of my head, sir.
All right. You, as part of your duties and responsibilities as the lead detective on the case, you requested swabs, did you not, of various parts of Miss Benefield?
We did.
All right. And that would include her left hand, would it not?
It would have included the areas that we were explained by her attorneys to pay the most attention to.
Did it include her left hand, detective?
You would have to probably direct that towards the crime scene tech that collected the swabs.
Well, how about if I use your report?
Okay.
Objection, Judge.
Yeah, if he's just relating what someone else said or did,
No,
I'm going to sustain.
I'm asking if he requested that swabs be taken of her left hand.
Okay,
That was the
that question can be asked.
That was the question. Did you request swabs be taken of Miss Benefield's left hand?
I requested the swabs be taken of her arms, legs, hands, and neck.
Okay.
That wasn't the question you asked the first time.
As part of your duties and responsibilities as a lead detective, did you ever get the laboratory results of those swabs from FDLE, Florida Department of Law Enforcement?
Was it FDLE or DNA Labs International?
Actually, I believe it was DNA Labs International. I stand corrected.
Okay.
Witness corrected
did you
the
get the
attorney.
results back?
Nice.
Yes.
Did you learn that out of all the people in the world,
Objection to asking this witness about the results of the DNA.
Again, you can ask your question and then we'll have the objection. Again, I make this ruling because there's no jury here.
I know.
So if I sustain it, I sustain it.
But he's testifying by asking the question.
well, did you learn that of all the people in the world, only 2 people could not be ruled out for having left DNA on Miss Benefield's left hand, John Sant, the neighbor, and Douglas Benefield.
I'm sorry.
No, do you have an objection?
Yes, that calls for hearsay and
Sustained.
misrepresentation of the report.
I haven't seen the report, but it's hearsay.
Yeah.
Absolutely.
Yeah. Yeah.
All right.
Anything coming out of
Detective, I
the
have a few
results of that
questions
report
now.
is
I'd like to
hearsay.
ask you about some areas that we discussed previously under oath. I had asked you at the deposition various things about Douglas Benefield. For example,
Objection is impeachment.
I don't know.
I gotta say the question.
Yeah. And so
He's getting
Do you
equally
have to say
annoyed
the
with both
question?
sides.
on a court statement, which is the first phase of hearsay. I don't know why it's going to be offered, but I don't know if you're refreshing our recollection, which is done a different way. I don't know if you're impeaching. If you're impeaching with a prior consistent statement, all I can say is, again, I need a statement here in open court, and then we can figure out if that prior statement was inconsistent.
Here comes the statement. Detective, do you have an opinion? How would you describe Mr. Benefield admitting that he shot a gun in the house, in the kitchen, to intimidate Miss Benefield to stop speaking?
Objection.
What's the question? How would you describe my statement?
How would you characterize such?
Hold on, I didn't hear the rest
I
of
don't
it.
even know what the question
I'm
is.
just asking him how he would characterize such an act of shooting a gun in the kitchen to intimidate someone from speaking any further.
You want this witness's opinion about how he would characterize without any frame of reference, meaning, what do you mean?
Okay.
He wasn't there.
Detective,
He
were you
doesn't
aware
necessarily know
that
the
there
full
was an
facts.
allegation that Douglas Benefield had shot a gun in the kitchen ceiling of their home to stop Mrs. Benefield from speaking any further?
I was aware, or I had heard that there was an incident allegedly that a firearm was discharged in the residence into the ceiling.
And would you describe that as a violent act?
I guess it all depends on the purpose and how it occurred.
Such as?
Objection as to his opinion.
Yeah, I'm going to
Well, it could be accidental.
And we're getting into a collateral matter, how this
It
witness
could be
would
some sort of
characterize an
mutual
act
joke.
that
I don't know.
he did investigate, he wasn't there for.
Yeah.
He's heard about
All right.
through some unknown
It's
source.
way
So,
too, it's way
no, with his opinion
outside
of
the
that,
scope of what's
I'm going to find is
acceptable.
irrelevant.
Were you aware during the course of your investigation, Detective, that there was an allegation that Mr. Benefield would punch holes in the drywall of their home?
I believe that I had heard something like that, but I don't recall where that was from.
And by the way, Sandra Ramirez, thank you so much for gifting 10 Legal Bites memberships. Very, very kind of you.
Sandra.
Very generous of you. And now Gwendolyn SS, Paul Diab, Kaylee, Analytical Blarney AB, Jill Sturgis, whoever, and Black Reindeer. It's popping up ahead of me. Ashley Boyer, Christina M. I think that's everyone. You are all now members of Bite Club, gifted by Sandra Ramirez. So welcome to Bite Club. Wonderful. On Fridays, if you don't know, on Fridays we do a casual Friday live stream for all members. Tomorrow I might be postponing because of this hearing, so we'll see how that goes. But otherwise, yeah, welcome to Bike Club, and thank you so much, Sandra. Very, very kind, very generous. And she says in a member chat, please don't forget to hit that like. Thank you so much.
Were you aware that there was an allegation that Mr. Benefield had beaten his first wife up on their honeymoon?
Objection, Judge, what is this?
Oh my God.
It is irrelevant what this detective may or may not have known about his past.
Well, actually, Judge, this detective has testified that whether Mr. Benefield had a violent background is something he would want to know, that it would be significant to his investigation.
Right. I'm not taking any of this for the truth of the matter asserted.
I understand.
All you're asking is, did you hear this? It doesn't prove that those things happened.
I understand that.
So I'm not sure why we're asking them.
And that would be the second question is, so what's the relevance of whether he heard that the decedent may have been violent towards, would you say a first wife? I don't even know who that is. I don't know when they were married, how long they were married. I don't know the
First
nature of their
wife, Renee.
relationship. So I'm going to sustain as to relevance.
Okay.
Yeah, he's
You
getting
are aware, or are you
getting
not,
outside
of
that box
an
pretty
incident
far.
where Mr. Benefield was seen by a neighbor at night standing in her yard?
Sorry. Yeah, actually, we discussed that during the deposition. I remember because I had some questions about it myself.
There's a police report that accompanied it Have you reviewed it?
I did it one time, and I believe that the witness said that there was a person standing there. And I asked you how we got him identified, because I guess they identified him by his voice, is what you told me, which I found odd, because why would you sneak around and then talk? Kind of, you know.
Did you review that witness's deposition?
I did not.
It's Exhibit 5 to our standing ground.
I don't have access to those, so.
Have you ever placed a tracker on anybody's car?
I'll overrule.
Have you ever placed a
Feeling, it
tracker
is
on
feeling
anybody's
like this
car
is
without
like the
the
best
appropriate
that he
legal
has
authority?
here. It's
No, but I've
kind
done
of
it with
feeling
the
that way
proper legal
because of how
authority
much
several
time
times.
he's spending on it, which is not good for the defense.
No.
I want to lastly ask you about some photographs of Miss Benefield. There were 2 sets of photographs taken you testified to, correct?
Yes, sir.
Some were on the
I don't think I should
evening
be a
of
trial
the
judge.
incident,
Court of
and
Appeals
then there
maybe,
was a
but
set that were taken a few days later.
it's
Yes, sir, that's
let's get to
accurate.
the
So to
point.
cut to the quick, if we
Yeah.
can, and not test what has up to this point been the judge's considerable patience. The
Patience
scratches
at you.
that were preserved in those photographs on Miss Benefield on the night of the incident, you saw them, did you not?
In the photographs later, yes.
Yeah, and they show as red and fresh, do they not?
They appear to be red, yes. I
Okay.
can't tell you how fresh they are. I'm not a wound expert.
Okay, well, they weren't scabbed.
Like I said, I saw a photograph later on.
Let me show you the photos.
Sure.
Let me just show them. Because I don't think that picks it up.
I understand why this officer is annoyed. I mean, he knows that he's being alleged, he's being claimed in open court that he's not doing his job properly. No one wants to hear that.
Consider.
No one wants to be
do they
litigated
depict
like that.
Scratches on Miss Benefield on the evening of this incident.
They appear to.
Okay, and do the scratches appear fresh?
I
I'm
don't
not a
think
wound
necessarily the
expert.
one up under the sports bra appears.
Are
to
they?
be.
What color are they? Are they pink?
Oh my
Like I
God.
said, I'm not a color palette expert, but I would go with sure. It could be pink or red.
Okay, are any of
I'm
them
not a
scabbed?
color palette expert.
It's kind of hard to tell because they're so minute.
Do you see any scab?
No, and I don't actually even see an open wound on this one that would scab over. So,
Okay, let me show you the photographs that were taken a few days later.
okay. Thank you, sir.
Pop quiz. How do you make a murder trial boring? Answer. Ask lots of inane questions that don't go anywhere.
Cora Savage, thank you so much for your generous
Why
super
are these
chat.
not
Hey,
more?
Lita, found you a year ago, right after Jesse Heard. I watched after I knew.
Yeah, if you're gonna use photos, I want,
This is the first
you
time.
either need to mark the ones you're using
being my
or use the ones that have already been admitted.
Thank you so much,
Because we
Cora.
need to have a
Very
record of
kind of
what you're
you.
showing the
Very
witness.
generous. Thank you for joining us. And I'm so happy that you've found LawTube.
And Madam Clerk, I'm fine if it's just defense 1, 2, 3, 4, 5, 6. You don't have to use letters.
Our trial attorney is just allergic to getting to the point. Is that the
We're
problem?
going to call these defense 1 through 6.
No, the prosecution has actually been pretty good at getting to the point pretty quickly, especially with some of these earlier witnesses. And honestly, and before this witness, this defense attorney was, in my opinion, doing pretty well. But I think this is, for whatever reason, this is a really big sticking point for the defense. And they're lucky that there's no jury here to make some kind of an impression, because, you know, he gives the impression that this is all they've got. This is their best point, because why else would they spend so much time on this?
That's exhibits 1 through 4, correct?
And
Yes,
yes,
sir, that's correct.
that was the back of the defendant's head, for those that were wondering. We have not seen her face in this hearing.
Now I'm going to show you defendant's exhibits 5 and 6.
Thank you.
I'm going to ask you if those are the photographs that were taken several days later.
You would have to talk to the crime scene tech about that for proper identification, but I believe so. Yes,
All right.
sir.
And is the color of those scratches different than the color of the scratches in the photographs that were 1 through 4?
Well, the scratch that was on her hip, the red scratch that I said didn't have a scab, that's not even photographed in any of these, just so you know. It's actually gone.
Mhm.
Other than that small little minute thing you can barely see,
Yeah.
there does appear to be some scabbing, but it's very, like I said, very tiny.
you familiar with the concept of blading?
I am.
And educate us a little bit about what blading is in the sense of it being a defensive posture.
Are we talking about it in regards to law enforcement?
No.
Okay, well, I'm not a jujitsu expert or anything, so.
I understand. I'm talking about with respect to minimizing the area of your body that is exposed to potential gunfire.
Okay, I guess if you were trying to minimize the area exposed, you would possibly turn your smallest side to it, which would be your side, sure.
Okay, otherwise known as blading.
If that's what you want to call it. Blading typically isn't a complete turn. It's more of a 45-degree angle or so.
Okay, again, to minimize the exposure.
Well, blading or interview stance, those types of things, blading is typically done like for our purposes. If I'm out interviewing a suspect, I'm going to blade my body and turn my gun sight away from them because honestly, that's more of a threat if they're looking at my gun while they're thinking about fighting me. I want to keep that away from them. It also provides for balance.
Right. You want to make sure that they can't get the drop on you.
It's more of a safety thing than an offensive thing, at least in my opinion.
Yeah, to protect.
Like I said, I'm not an expert, so.
To protect you. As part of your investigation, you determined that the firearm that was used to shoot Mr. Benefield was owned by Ashley Benefield.
One of our detectives, I'm sure, would have done that part of it. I don't recall doing that part myself.
All right, but you do recall it was lawfully owned by her.
As far as I'm aware, yes.
Yeah, and that she had a concealed weapons permit.
She may have. I don't remember she did at that point, but it's possible.
I don't believe I have anything further, Your Honor.
Oh, good.
Thank you for your patience.
Whew.
Redirect? All right, can this witness be excused?
Oh my gosh. Made it.
Mr. Taylor, can the witness be excused?
Yes.
All right, Detective Warren, you're excused.
It's been
Thank you, sir.
84 years.
Yes, sir. There's a couple papers. You want those too? Oh, yeah.
This case is going to trial. I'm going to just spoil it for you.
I think so. I think so.
Mr. Taylor, I think these are yours papers
We're about 4 minutes behind
and
now.
your paper clips. Yes, sir. All right, State.
The next witness is going to be a little lengthy. Do you think we can take a 5-minute break before we start?
Sure, absolutely.
Then we will be right caught up.
Can't see that. It is 4:06. How about 4:15? Maybe a few minutes after 4:15.
Okay, thank you, sir. Thank
All
you.
right, we'll see you then.
Cool.
All right. So I will go ahead and fast forward to the present. And yes, so we are all caught up. Here's a question from Dionysia Jaclo. Stupid question. No such thing. Why is it being called the Black Swan trial? The reason why it's called the Black Swan trial is because of the fact that she was formerly a ballerina, just like in the movie Black Swan. If you've seen it with Natalie Portman, she plays a ballerina who is like an elite ballerina. She becomes very obsessed with perfection. She kind of like descends into madness throughout the film. It's a really good film, but also very, very, very creepy. And I think she got this nickname during their divorce. I think it was one of the either maybe not his attorney, but someone else that was like on Doug's side of things that like labeled her as like the Black Swan. Like, Doug had wanted to believe that she was this white swan from Swan Lake, because he was so in love with her, but he didn't realize that she was actually the Black Swan underneath everything. And so it was like this big metaphorical thing. And so Court TV has been running with the Black Swan murder case, and I guess Law and Crime. I think they're also calling it that. But that's what folks are calling it. So yeah. And the other connection with the ballet is that she had I don't know if maybe it's right to say she had convinced him, but she was the one that was the former ballerina. He never had any sort of experience or interest in the ballet before he met her. And then when they got together and they got married, they decided to start the American National Ballet or something. I wrote it down here somewhere, but yeah, it's something along those lines. Essentially a ballet company in Charleston, which basically immediately failed. So, as a business venture. But yeah, that's been, yeah. So it's yeah, Marissa M. It is catchy. It is definitely catchy. It's very catchy. So, if and when it goes to trial, It'll be a very, very interesting one for sure. Very spicy, it seems.
As we're killing time, do you mind if I talk to the chat about the technical difference between justification and excuse?
Yeah, go ahead.
Okay. So they talked in the trial about justification and excuse. And I was like, what would excuse be for murder? Because it doesn't really normally apply. So there's a technical legal difference between the two. Justification is I did the thing, but I had a really good reason. Excuse technically is basically I didn't do the thing. It basically is it is a legal attack on one of the elements of the charge. So in the case of justification, it's like, yes, I did all the things. I intentionally shot the guy, but I did it because my life was being threatened. An example of excuse would be duress, for example. Yes, I went into the bank and robbed the bank. It was because, the bad guy had a gun pointed at my wife's head. And he said, if you don't go into the bank and rob the bank, I'm going to blow her brains out. Right? That's kind of thing. Right? So that technically doesn't qualify as a justification. That technically qualifies as an excuse because you're attacking the intent element of the mens rea. And another one would be doctrine of necessity. I did the thing because I was required to avoid some larger thing. But I'm like, there's no real excuse defense available for murder because I can't think of any scenario where it's like you can argue technically a legal excuse. So I was giving him a hard time because I'm like, those are technically different, and I'm not sure that you can do that here. So
I guess
anyways,
war maybe.
Maybe, yeah.
So yeah, I don't know.
Yeah, there you go. That would work.
That was a
So
great
maybe,
explanation.
or maybe
Thank you, Kurt.
as the executioner for the death penalty because you're being authorized by the state. So it's technically,
I guess
yes,
so.
you killed the guy, but it's legally excused because you have permission to do it. So there you go. Yeah. Okay. So you found one.
Yeah. And Congress declares war, so
Yeah, there
it's
you go.
similar.
Yeah.
You kill people from another country because Congress has declared war on them. Legally justified in our book.
There you go.
Yeah, I suppose. But I guess those are obviously very limited circumstances.
Yeah, that's hyper technically correct is the best kind of correct discussion right there.
Exactly.
Yeah.
Oh man.
All right, Madam Court Reporter, we are back on the record.
All right. That was like perfect timing.
Or maybe a police
And
officer doing a
take
drug
care
buy
of,
would be an
speech
example of
45.
excuse
Yes, the state would
because they're
pass
legally
it into
authorized.
evidence.
Defense.
Okay. Pressing on.
Makes sense.
Yeah, these are the text messages, which.
Correct. Yes, sir.
we rejected because of relevance. We still believe them to be relevant, but as Your Honor has noted.
I wonder how much longer we're going to be going.
So
It's what, 4:00 East Coast time?
Relevance.
Judge, the relevance is the tenor of their relationship. This is all after she's made all of these allegations against the defendant, or I'm sorry, against the victim, and all of them have been shot down. And then she's having, she's telling people that she's afraid of the defendant or of the victim, I'm sorry, and she's afraid for her child, but yet she's having these text conversations with him that clearly there doesn't appear to be any fear, and it helps set the tone for their relationship.
All right. There was also, I know relevance was now, but there was also the objection to hearsay, not as to obviously the text attributable to the defendant, right, or come in.
Right.
But what about the argument that any text by what's alleged to be Mr. Benefield hearsay?
I would have to know which text specifically, but like, for instance, he says, trucker on the way as the last text. So my argument for that would be statement of intent, that hearsay is allowed to come in if it's a statement of intent by a witness and the state is trying to show that the witness complied or acted in compliance with that statement. So that would be my response to that. The other ones of good morning, good night, those aren't offered for the truth of the matter is for
All right. Yes, Mr. Taylor. So
We are not
there's
asserting that
an
it actually was
interesting
morning
objection.
or
So
night
anything else you
during
wanna
that
put on the
time that
record?
text message was sent.
I I don't believe so, Your Honor.
It was probably one of them.
More concerned with the next witness that I'd like to take up with the court.
All right. Well, there's some foreshadowing for you. Okay, I'm going to allow
It's a nice
I'm
mug.
going to overrule the objections.
Thank
to,
you.
Defense.
It's a
States-
set.
45
one is a different
is
color.
admitted, that being the text messages. I find them relevant solely for the purpose of the state's argument, and that's the only way that I'm going to take them, because that's why the state has said they're offering them, is just to show the nature and tenor of the communications and the relationship between the parties in the days leading up to the event. And as to hearsay, certainly any statements made by the defendant or attributable to the defendant as part of this text messaging would be admissible under the rules. And as to the other ones, again, I don't find that they're offered for the truth of the matter asserted. With the good night, the good morning, what do you need at Lowe's? You want to go to Panera? I'm taking it solely for the purposes that the state has said they're submitting it. So I will overrule on that.
Who doesn't want to go to Panera?
That's a very good point. Maybe someone who's tired of sandwiches.
Have you been following any of the Supreme Court stuff this term?
I haven't been. I know that there's been some decisions, and especially in recent weeks, that have been huge. But I haven't actually sat and like read any of the opinions on any of those. Partly because I typically stay away from political subjects on my channel. So and those kind of teeter towards
It's not political, it's legal, baby. That's what I'm saying.
I mean,
So
it is legal.
if
It's
there's
coming out of the
concerns, let's
Supreme
hear 'em
Court.
now, I
But
guess. If they're
you know,
general concerns
there's
as
a touch
opposed
of
to,
politics, and there's been
discrete
other stuff to
portions of
talk
his
about at the
testimony.
same time. So it is nice having some realms in this world that don't talk politics.
Only because this is the detective, Judge White, that was assigned to the DCF cases and the allegations of abuse by Mrs. Benefield against Mr. Douglas Benefield. And I don't think it has any relevance whatsoever to the proceedings. I think that we're going to end up in a dispute as to what the conclusions were, that is to say, unfounded, unsubstantiated, as opposed to ridiculous or nonsense, that kind of thing. It's one thing when something is not proven by insufficient evidence. It's quite another thing when it is determined to be unfounded. I don't know that any of the DCF people who actually made the decisions are going to be present to be able to be
Susie Lynn, I believe she is
cross-examined.
out on
And I think
bail.
even if they were, I don't think that that's a road that we want to go down.
Believe it or not.
Because again, I don't think it has any relevance to the proceedings.
Well,
at
you
all.
should definitely cover the
Even if we
suitcase murder
give the
trial with me
state
and the Crumbly
the
trial,
benefit
because
of their
both
theory
look interesting to me.
in creating motive and showing what they want to show, such as
Yes,
text
it's out at
messages.
the end of the month, right?
parties that they
Unless
coming up
somebody pushes
soon.
back again.
I
coming up
don't know
soon.
what the substance of the abuse allegations lends to that.
We will have to see, because
right,
I might also be
let me
taking
just
some
say this.
vacation time. That's
That's where my
the only
mind
thing
is
that would
going,
interfere.
but I don't know anything about these allegations. I don't think it's in any of the paperwork.
I can tell you, Judge, my intention, and it's for the same reason that I entered Judge Moreland's oral order for the previous things. I do not intend to get into anything other than there was a complaint, who investigated, was it sexual abuse or physical abuse? And
Doreen, thank you so much
against
for
who?
being here and for
then
modding.
Was it
Thank you.
investigated and did this detective?
Have a good
close the case?
rest.
Or, file the case, or how did it work?
Let me get a little bit more. Oh, hold on. As you may have noticed, I'm pretty big on procedure. And so I go
Respect.
with proponent, and then I come back to the non-movement or non-proponent, and then I come back for rebuttal. So when I come to you, tell me everything you want to know, because I don't ping pong back and forth. But I have questions.
Yes.
Because
Don't
I
we
don't
all?
know anything about this. Who are the complaints against?
The complaints are the defendant making complaints of sexual and physical abuse against the victim.
Regarding what child?
The same child, Emerson.
Emerson.
Yes.
Because I've heard about an older child.
Yes.
And
we will
Emerson.
establish that.
All right, so these are complaints made by the defendant
Yes.
against the decedent
Yes.
regarding their natural
Their
child.
natural child who was a toddler at the time.
When were they made?
I have the dates.
The child or the complaints?
December 10th, 2019. March 21st, 2020. March 23rd, 2020. April 5th, 2020. And April 27th, 2020.
Oops, sorry. All right. So tell me, what is your theory as to why these tend to prove or disprove any material facts that I need to consider?
Well, to me, there are two issues. There's credibility, ultimately the credibility of the defendant, because we have to take the facts as known by her, or at least as she's saying. So the credibility of the defendant is an issue. So some of these things that I'm getting into go towards the credibility or lack of credibility. These things also go to the motive for this, because the defendant attempted in court over and over and over to stop this communication with the child, and Judge Moreland stopped that. So she changed tack and then went to abuse against the child as opposed to supposed abuse against her. And she attempted for the abuse against the child. And she even makes comments to a witness that we're gonna have later on that nobody will help me, what am I gonna do? Nobody will listen to me, because these reports were not being filed by law enforcement. And then at the time, all of this is going on at the time they're goodnighting it in the text messages. So
All of what's going on?
these complaints are going on before the text messages where they're.
Yeah, I was going to say, because those are from the week before. These are months before.
Yes, so these had already been made, I apologize. These had already been made at the time that they're talking like they are here. And her argument is, I just want to save my child. That's the only reason I'm around him. This is all going to come out later on. And otherwise I would never be around him. Nobody will listen to me. I have to move to Maryland to get a new family jurisdiction. So this goes into everyone. She had exhausted, in the state's opinion, every avenue that she could to keep this man away from the child. And when she felt like no one else was going to do anything, this was the result.
All right. Anything else?
No.
All right. Now, sir.
So, Your Honor, you wear the robe. But all I can say is, as I tried to explain in my opening statement, the parameters of the Stand Your Ground statute require the state to prove by clear and convincing evidence why the force used was not justified. I don't see how motive has anything to do with that. I also don't respectfully see how complaints about abuse have anything to do with that. And what I'm particularly concerned about, and the reason why I think it's going to be, to a great extent, a depletion of the court's time unnecessarily, is that this detective was not the one who received the complaints. That would have been DCF. So this detective, whatever he has to say, is going to the extent it's substantive, is going to be based on rank hearsay. That's number one. Number two, I'm concerned about this detective offering an opinion as to how the case was closed. Assuming the court were to allow it, I could understand if the state asks, and was the case closed? Yes, okay, next. On the other hand, I could not understand if the question is, how was the case closed? Well, it was closed as unfounded. In other words, there was not a scintilla of truth to it.
Not a chincilla of truth.
Examine this detective based upon that conclusion, which was rendered by somebody else.
All right, so what I'm hearing is this detective, he's a CAC.
Yes.
All right, crimes against children. A complaint was made
Yes. To the sheriff's office,
by the defendant.
5 times, yes.
Hold on. For each individual complaint.
Yes.
Complaint was made by the defendant on such and such a date against the decedent. Just a very broad category alleging some sort of abuse against their natural daughter. It was investigated and it was closed. Right? That's all you want.
Judge, I believe its effect on listener the same as Judge Moreland's order, the fact that it was closed unfounded. That is the part that has an effect on the defendant. I'm not offering it to prove that there was no evidence of it, just that the defendant.
And this is the weird thing, because I've heard that now, but
Right.
I think the point is, what your point is, it was closed and no action was taken, whether it was unfounded, unsubstantiated, fanciful, improbable. I don't even know what I do know unsubstantiated, unfounded. No, I think those are the baked ones. I'll allow that. I'll allow the fact it was closed with no action taken.
If I could just let him know.
Yeah, let him know,
you're not a jury.
and I'll prepare the curative instruction for the jury.
Okay.
But at the end of the day, I understand, and this is what I was saying earlier to the defense is, I understand the point you're trying to make. I get it. I know where you're going. No problem. I'm with you. I'm following you. The same as with Mr. Taylor. I just think there's a much more direct way to get there. All right. In fact, quite frankly, if that's all it's going to be, there could probably be a stipulation here, but that's all I'm going to allow. And then you can argue at the end, and you can argue at the end the opposite side.
Okay.
Okay. That she was absolutely privileged to make these complaints, and she must have had a good faith basis to do so, and so be it. There was no action taken.
I wouldn't have a problem stipulating to that.
Judge, I would rather call the witness.
That's fine. And I'm not, listen, I just threw that out there. You know how I sometimes do things gratuitously, which I shouldn't. So go ahead.
State calls Detective Brian Moreland.
I'm prone to gratuitous musings.
I just want the court to know I tried to.
He wishes.
No problem.
He
I
has
just
secret
want the
desires
court
in
to
his
know I
heart.
tried to save time. That's what the defense attorney said. After everything that he did with the last witness. Okay, dude. And Dionysia Jaclo, yeah, I think we are so in a gray zone here. This is totally going to trial. I don't think it's a hugely winning case on either side. Like, I don't think either side has a slam dunk in this.
Oh, did you get a chance to go talk to him?
No, but I'll lead.
Okay. On that one issue, I'll probably allow a little bit of latitude on leading just to keep it clean. Hello, Detective.
Hello.
Sir, make yourself comfortable in that chair. Adjust that microphone up, down, left, right, however you need. Just a loud, clear voice. We should pick up everything.
Thank you,
Thank you,
Judge.
sir.
Please state your name.
Detective Brian Moreland,
Where do you work?
Manatee County Sheriff's Office.
Okay. Are you any relation to Judge Moreland?
No, ma'am.
Okay. How long have you worked for Manatee County Sheriff's Office?
Since 2004.
What is your current position?
I'm a crimes against children detective
How long have you done that?
since 2011.
And what does a crimes against children detective investigate, just generally? What kinds of crimes?
We take general assignments.
gonna guess crimes against children?
Any kind of abuse, neglect, death investigation, sexual abuse, things like that. Anything
Of-
that happens to anybody under the age of 18 years.
Okay, so of children.
Yes.
Okay. When you investigate either of those allegations, either physical abuse or sexual abuse, do other agencies all work together with you?
Other entities do, yes, ma'am.
Entities. Okay, and who are those entities?
Generally, child protection, the child protection team, which is here in Manatee County. And then what I would refer to as DCF or Child Protection Services.
Okay, so I just want to make clear, you're law enforcement, so you do investigations for criminal charges.
That's correct.
Okay, and if DCF is involved, they are not investigating for criminal charges, correct?
Correct.
Okay. So they have different goals, I
Yes,
guess is my point.
Their goal is the safety of the children involved.
Okay. And CPT is not a part of DCF. I just want to put that on the record.
No, ma'am.
Okay. When there's an allegation of abuse, what is the protocol? Who goes out to investigate first?
Generally, what happens in at least my criminal investigations is once the allegations are made, they'll go through the Florida Abuse Hotline. CPS would get involved, call for law enforcement. Generally, what happens is a uniformed law enforcement deputy goes out and takes the initial investigation. If further investigation is warranted, it'll make its way to our office and get assigned to a detective.
Okay, so, and during this process where there's an initial law enforcement officer, is there typically someone from DCF there? I think you said CPI.
CPI,
Okay, which is a part of DCF.
yes, child protection investigator.
Okay. So only when further investigation is needed do you get assigned?
Correct.
Were you in that position, the same position you're in now back in 2019?
Yes, ma'am.
Did you become familiar with someone named Ashley Benefield
Yes, ma'am.
and her child with Doug Benefield, Emerson?
Yes, ma'am.
Were you involved in investigating a series of allegations starting back, I guess, in 2017, but really in 19, I guess is what I want to concentrate on?
Yes.
Okay. Let's start with the first allegation that came in 2019, the date of December 2019.
Yes, ma'am.
Do you recall that
Yes.
allegation?
Mhm.
Okay. And without getting too much into the facts of it, what type of an allegation was it?
That was a sexual abuse allegation.
Sexual abuse allegation, and the allegation was made by
The reporting party was Ashley Benefield,
Ashley Benefield, and saying who was doing the abusing.
Doug Benefield.
Okay. And clearly you opened up a MSO case number on that.
It was opened by the uniformed deputy.
Already open. Okay. So at this time, the uniformed deputy had already gone out as well as the
People who abuse
child
children, I mean,
protection
it's just
investigator.
like,
Yes, ma'am.
Okay.
Yeah.
Do you know if she went to CPT that time?
In 2019, she was seen by Dr. Riley at CPT.
I was
Okay.
covering a case
And
today on my
CPT, that is
channel
a
where
medical
a
exam?
babysitter
They
murdered
performed two
a
functions for us.
like a
In my
15-month-old
criminal
after
investigations,
previously
they do
seriously
forensic
injuring a
interviews for
2-year-old.
us
Oh my
and
God.
also
I'm like,
medical evaluations.
Why?
With respect to what we're talking about with
Oh,
Emerson,
those are the worst cases.
she was, how old?
She was too young for
Too
a
young.
forensic interview. Yes.
How old was she? Like 2 or toddler?
Yes.
Okay.
Oh, so this is essay against a toweler. Oh, that's great.
No, against
After
Ashley.
this
she
first
says.
Okay.
complaint came in or allegation came in, did you investigate?
Yes, ma'am.
Did you speak with the parties or speak with Doug Benefield?
I did.
Okay. And did your conversation with him give you any concern?
No.
Okay.
Sustained.
And you eventually just closed that case with no charges, correct?
That's correct.
All right. So I want to talk about the second, what I call the second report. Do you know what date that came in?
Are we referring to a 2020 report?
Yes. Yeah.
May I look at mine?
Yes. Go right ahead.
Thank you for the trigger warning, Sandra Ramirez. There are going to be allegations of abuse here, all kinds of different
The
abuse
report date
allegations.
on that was
So,
March 21st, 2020.
Okay. And
so let me just make the point really quick. If conversations about abuse, details about abuse are difficult for you, there is no need for you to subject yourself to trauma, re-traumatize yourself if that is something that you struggle with. If you are finding that you are having a hard time with the testimony at any point, take a step back, walk outside, do whatever you need, cuddle with some fur buddies, or something. Do whatever you need to feel better, and then come back when you're ready, at whatever time feels right for you. So just want to make that very clear.
that was also obviously given an MSO case number. What was that allegation?
That was a physical abuse report.
Okay. And that was, again, by Ashley Benefield saying Doug Benefield was abusing the child, Emerson.
Yes, ma'am.
Okay. To your knowledge, did a deputy and a child protection investigator respond initially before you got it?
Yes, ma'am.
Okay. Before you could fully investigate that case, did another complaint come in?
A few days after that, on the 23rd, another deputy responded to Miss Benefield's residence and conducted another interview.
Okay, so another allegation, same parties.
Yes.
All right. And what type of an allegation was that?
Also physical abuse.
Physical abuse. And did you investigate both of these reports kind of together?
Yes.
Did you ultimately close that case?
Yes, ma'am.
With no charges?
No charges.
And then the fourth report, can you tell me what date that was?
Manny
Report
B,
date on that was
that's exactly what they're trying to go for.
April 5th, 2020.
Okay, and what was the allegation?
Also physical abuse.
Same parties,
Yes, ma'am.
same allegations, okay. And again, a deputy and a child protection investigator responded. And at some point you were assigned the case?
Yes, ma'am.
Okay. And again, before you could fully investigate this, did another complaint come in?
That I don't recall.
Okay. I have something dated April 27th of 20. Do you have any notation of that in your file? With Deputy Schrank?
This is when he responded to Ashley's residence, yeah.
Okay. And that was on April 27th.
Yes.
And that was another allegation, correct? New bruises and sexual abuse?
Allegation of bruising and marks. Yes.
Okay.
Ooh.
Same parties?
Yes, ma'am.
Did you investigate this case or these two cases?
I did.
And ultimately, you closed those with no charges?
That's correct.
Okay. Thank you. I have no further questions.
No, is that it?
Well, cross-examination
Mr.
now.
Taylor? Cross?
No questions for detective.
Okay. Well,
All right. Can the
I was
witness be
getting worried
released?
there. I was
Oh.
like, I'm gonna have to peace out.
All right, sir, you're released from your subpoena. Thank you.
But it wound up being real short. So okay.
Yeah.
State would call Dr. Broder.
This one we need to have a little powwow.
Okay. Don't bring in Dr. Broder yet. Thank you, Deputy.
Thank you, sir.
All right. Go ahead and put your objections on the record, and then I'll hear from the state.
Your Honor, for this, I rely exclusively on the Florida Evidence Code, which is really, really clear about character evidence. And I've read these reports. What Dr. Broder is going to testify to about Ms. Benefield and his conclusions clearly go to her character. And the evidence code says in no uncertain terms, it's inadmissible until such time as the defense puts her character, if at all, in issue. What is admissible is Douglas Benefield's character. According to that same statute, I gave the court a memorandum on it. I know while I haven't spent that much time before the court, I have spent enough time to know that the court reads everything. So I know Your Honor has reviewed it. I don't think, honestly, Judge, there is an exception to it. And what I'm particularly concerned about is the state is about to call a professional who's going to opine as to characteristics of Ms. Benefield that really have no place in this hearing. And while I firmly believe at the end of the day that Your Honor will parse this appropriately, I have some real concerns about this kind of testimony and whether or not the court would be capable of that. So I think it's improper.
All right. State, what do you expect Dr. Broder is going to testify about?
Okay, there are several things. Most of what I try to keep Dr. Broder's testimony to is his observations of the defendant and the victim and the child. Also things that the defendant told him. So I try to section this out to sections that I did not believe would be objectionable. But then there is a section where he does talk about some testing that he did, and some of his opinions and diagnoses of her would suggest that she has, it would probably be improper for me to get too far into it, but suggests that she does exaggerate facts, that she does exhibit paranoia about things. And I think that is highly relevant to the self-defense argument. First of all, I believe the defendant has put her character into question by asserting self-defense in the motion, even though we're not technically in trial. But I do agree that character evidence only has certain ways that it can be proven, and that's not what the state's trying to do. What the state is trying to do is the court has to determine if this use of self-defense was valid based on the facts as they were known to the defendant at the time. And as I've argued before, the only person that knows the facts as were known to the defendant at the time is the defendant. And if a professional has investigated her and evaluated her extensively and says she has a tendency to exploit the facts and exaggerate the facts and be a victim when she's not necessarily a victim, I think it goes to the facts as seen by the defendant at the time and the reasonableness of her belief that she needed to use deadly force.
All right, so let's talk about that one first. And you can sit, you don't have to.
Okay, it's just hard.
I understand.
To remember to do that.
And if you want to, that's fine. If you want to stand up and move around, that's fine too.
Okay.
That's very kind of him.
So we certainly have to look at the use of force as informed by the facts and understanding that the defendant had on that day, which sometimes misleads folks into thinking it's a subjective test. It is not. It is knowing the facts that would have been within the defendant's ambit of knowledge at that time. What would a reasonable person have done? So I don't look at what would a reasonable person who tends to exaggerate situations. I'm not concerned with a reasonable person who's paranoid or mentally ill or schizophrenic or any of those. I'm just, what are the facts that were available to and known to the defendant? And were the actions of the defendant reasonable in looking at it from the perspective of a reasonable person? So I guess I'll say that I'm not seeing, and I'll come to you. Don't think I'm not coming over there. I am. But before I go over there, I want to make sure I understand what the testing of the defendant and the diagnosis that she exaggerates and may suffer from paranoia, to the extent that those are diagnoses, DSM-4 or 5, whatever we're on now. So I want to hear a little bit more about that.
We need to bail out for now. I'll come back another time.
What the observations
later.
of the
Thanks,
defendant,
Kurt.
Bye, guys.
victim, and the
Joining.
child, what those are, when were they? and what's
Also,
the
Debbie Faison
relevance
Cook,
of any
thank you so much for
observations
gifting
that
one
that
Legal Bites
witness may have
membership.
made? Defendant
So
statements,
James
another
Woolard,
issue.
you have been
I'm not gonna
gifted a
spend lot of
membership
time
by
here, 'cause
Debbie.
If she made statements
And
to
welcome
them,
to the Bike
as
Club.
long as they're relevant, they're coming in. But those two things, I'm not quite understanding the testing of the defendant and any diagnoses by Dr. Broder and how that's relevant to the objective person standard, and then the observations of the interactions between the three of them.
Okay, which one do you want me to take?
Whichever one you want first.
Okay, Judge, as far as the testing, I agree that it's an objective standard. But if your only recitation of the facts is told by someone who suffers from histrionic personality disorder and makes herself a victim all the time, then her view of the facts, it goes to her credibility. Her view of the facts as is being put forth in the motion and possibly in this courtroom,
Joshua
it's not
Tenhag,
necessarily
thank you
as
so much for
reliable.
gifting 5
Let me
Legal
ask you
Bites
this.
memberships.
Is the
Mandy May,
defendant's
Cynthia
motion
Main,
substantive
Billy
evidence
Marie.
that I can consider?
Let's see, who
I
else?
think the defense would say
Kanapka,
But I'm asking
Z,
you.
no.
I'm just gonna ask that limited
Pashtatam, I
question.
think.
Is the
I'm so
defendant's
sorry if I
motion
mispronounced that. And also
substantive
Flyers Gal 12.
evidence
Welcome to
that I
Bike
can
Club.
consider?
Absolutely.
Wonderful.
And you have a
Thank
case that
you.
says that. I don't think it's not sworn to, is it?
No.
Now, hold on. Let me say this. I completely understand that in order to make a prima facie case, and I believe this as well, not just I know this is the case law, that a motion to dismiss under the stand your ground statutes does not need to be sworn to. All it has to do is set forth a prima facie case. So with that said, though, how do I consider that as substantive evidence when it's a motion written by the attorney on behalf of the client? And I don't see any manifestation of an adoption of that.
Well, I can answer that. Number one, the state has stipulated and acknowledged that it meets the prima facie.
That's it.
threshold.
That is a pleading threshold.
Yes.
That's not a substantive evidence threshold. All it is a pleading threshold.
Right, and the appellate court has said that Your Honor is obligated to take the averments as true.
In determining prima facie, and I agree, there's a prima facie case. My question is, under what authority, so I'm looking for a statute, a rule, or a case, says that an unsworn motion to dismiss under stand your ground can be considered as substantive evidence?
Well, I think at this juncture, the only inquiry for the court is whether or not the state produces evidence clearly and convincingly that the force used was not justified.
100%. I agree with that.
And that therein exposes, I think, her argument in this sense. Whether or not Miss Benefield exaggerated things has nothing to do with what the state, at least up until now, has yet to produce. I was going to use scintilla of evidence, but I'm kind of burned on that one. Has yet to produce.
That's because
any
it's chincilla of
whatsoever,
evidence,
which
sir.
is the violent nature of Douglas Benefield. And was my client the objective standard on that day, knowing what she knew about him, firing the gun in the kitchen, placing a tracker on her car, was she justified in resorting to deadly force? I've yet to hear anything about that refutes that. I only have heard a case that is intending to show motive.
I appreciate that for your closing argument. My question is much, much more narrowly tailored. Can the court consider the defendant's motion to dismiss for stand your ground reasons that was written by the attorney, is not verified, has not been adopted as a defendant's statement, as substantive evidence? And so we'll leave that right now on the table because I'm not aware of any case law that says it's substantive evidence. But let me come back to you. And I think I kind of got off on that tangent. Based upon the observations, is that where we left off? Or is this still on the testing?
I believe it was on the testing.
Okay.
Brothers testing.
Okay, so yes, I think that's where we were. We were talking about how the court does have to determine the facts as known to the defendant. And when you're evaluating what's known to the defendant, I think the credibility of how she views things is highly relevant to the recitation of the facts. And so I don't know how the substantive evidence or non-substantive evidence in the motion to dismiss plays into that. The burden has shifted to me. She has said self-defense, so I do feel like we have to prove otherwise. So the fact that she has these traits and has been seen to do it, I think plays into the facts as known to her.
I think if there's going to be substantive evidence in front of me, all I know right now is that a prima facie case has been pled. That's it. Now the burden shifts to the state to prove by
Clear and convincing evidence.
competent and substantial evidence that proves clearly and convincingly that the defendant is not entitled to. But I don't think the facts as alleged in the defendant's motion are substantive evidence. I'll look back through my notes, but I know there's been a lot of cross-examination on allegations of prior violence and so forth. And my take on that all has been, well, yeah, I heard about that, but not, yes, that happened, or yes, it's true. I haven't received, I just don't consider that as let's just call it proof. So I think if at some point the defendant's statements are in front of me, whether it's here in court or was it a recorded statement?
Yeah.
Okay. So for right now, I just don't think that beyond the fact that there's a prima facie case of self-defense and now the state has to rebut that. So I'm not at this point. I mean, there might be rebuttal where Dr. Broder can bring that all in, but at this point, I don't think it's relevant to preemptively show that she exaggerates or is paranoid. All right, now on the observations.
On the observations, it again goes to the state's allegation of motive that she is trying everything to get rid of this victim, and she's tried violence against her and it hasn't worked. She's tried violence against the child and it hasn't worked. And
So it goes to her credibility and motive that she's telling the defendant one, or I'm sorry, the victim one thing, she is acting another way in private. It shows that she is being manipulative and she is not at all wanting to have this nice family relationship, which goes to her motive to get rid of him. She doesn't want him around.
All right, let me take even a further step back. And this is an example of where you guys know the case so much better than me. What observations do you expect Dr. Broder to testify to? I saw it on this day. I saw this on.
The seeing is mostly with the child because the allegations were of abuse and the seeing is the child interacting with mom and dad. The rest of it is the defendant's statements.
All right, so the observations, I'm only talking about that right now. The observations portion, which was number one of the testimony you intend to elicit from Dr. Broder, is that he observed the decedent interacting with the child, Emerson, presumably in a positive way. And the child didn't exhibit any external manifestations of fear or.
Correct.
Okay. When were these observations made?
And I have to look at my questions, but the report was set to come out. It came out, I think, a week before he was killed. So he met with them 10, 15 times. So I'm not sure exactly what date, but I can tell you when he was asked to do the report, when he was assigned to do the evaluations of the two of them. It was. They don't have the date. Hang on, Judge, I'll find it.
Here's a question from N Black. Do lawyers always object to every witness, or is this just a special case because it's a hearing? Usually objections about witnesses at trial are going to be done in advance, like before the trial happens, because the same frustrations that we're seeing from the judge here during this hearing, the judge wants to avoid all of that at trial because not only is his time kind of being wasted, but the time of the jury is also being wasted. So he always has an interest in making trial run smoothly and efficiently. So these objections will happen about witnesses, but they will be usually in pleadings ahead of time. They'll go back and forth in written filings, and then they'll often they will have a hearing on those motions where they argue back and forth and the judge makes the determination very often. So those are called motions in limine.
But like I said, he saw them on numerous occasions, so.
And your intention of offering the evidence of the observations by Dr. Broder of the interactions between the decedent and his daughter is just simply to show that she didn't seem afraid or scared of him.
Correct.
Right. So that should be one question.
I think he's entitled to say why he thinks that.
Well, I mean, yes. What did you observe? Because otherwise it's conclusory.
Right.
But he's got to put the facts on there. But
Right.
Okay. And I'm going to come to you in a second to hear your other portions. And then on the defendant's statements, I mean, how numerous are these? If they met 12 times, are we going to hear hours worth of defendant statements?
No, I don't know how long it's going to be, but there's several statements.
Okay. I don't know what they are. All right, sir, Mr. Taylor, so I've already said I'm not going to allow the testing and the diagnosis until I think there is substantive evidence in the record of defendant statements or character that would allow that to be used. Maybe in rebuttal, we'll see. But now to observations. Did you want to be heard on the observations of Dr. Broder?
Well, let's assume, I think the court got to it right quick. Let's assume that he's going to come in, he's going to testify. I observed Douglas Benefield with Emerson, and Emerson appears to be quite happy. Okay, so that's, I guess, another way of establishing that the complaints were closed with no finding. So it's, I guess, reinforcing the state's establishment of motive. So the question becomes, for something that's not an essential ingredient of this hearing, that does not go to one of the facts and issue, just how much reinforcement to a non-essential element is the court going to allow? I don't think that there's a thing that Dr. Broder is going to say about observing the interaction between the father and his daughter that's adverse. I think the court figured that out pretty quickly. So then the question is, so what's the relevance of it? What's the benefit of it? What's material to it? Because it does not run to supporting any fact and issue. What I do think, Your Honor, is that if she is allowed to call Dr. Broder and Dr. Broder is allowed to testify, I believe I can question Dr. Broder about his conclusions as they related to Douglas Benefield. I think that the evidence code clearly provides for that. I have alleged that Douglas Benefield was violent. I've attached to our motion, which I think the court can consider substantive evidence, admissions by Mr. Benefield under oath. And I am entitled to bring out from this psychologist.
That chime always reminds me of Star Tours at Disneyland.
That he concluded Douglas Benefield
Star Tours, now leaving for Endor.
Obsessive control, obsessive compulsive personality, and that somebody with that diagnosis likes to control their circumstances, their situation, which would include, according to Dr. Broder, quote, their marriage, parenthetical, Ashley, end parenthetical, quote. Dr. Broder also hears Ashley's chief complaint, which is that he's violent, he's jealous, he's manipulative. These are things that she feels. If the state wants to go down that road, I think then I'm entitled to cross on it.
All right, I don't know because I haven't heard his testimony yet. It may be within the scope of direct and it may be outside the scope of direct. I don't know how far they would get into that. I think that's more of a game time decision. All right, State, any final thoughts?
No, I just want to put on the record that I disagree that if I do get into certain things about the defendant, that it opens the door naturally to talk about his impressions or diagnosis of death. I think I would like to see that rule of evidence.
And that's why I said, I don't know. Because I don't know what his testimony is going to be. Certainly it's something that could happen. I don't know. You know, maybe it's relevant to some issue you raise. I don't know. But more specific to the observations that Dr. Broder made regarding the interactions between the decedent and the child, the ruling is much like I just made with Detective Moreland. If you want to get a little bit at, and let me be clear, if I'm understanding how this is going to come full circle, that a couple of days before, this is what I'm understanding from you and from what I'm piecing together as we go forward. A couple of days before the incident alleged in the information, Dr. Broder issued a report, and that the defendant would have seen that report, seen that Dr. Broder made positive observations regarding the interactions between the victim and the child, and that supports the state's theory of why she did what she did.
Your Honor, I'm sorry to interrupt, but Ms. Benefield never saw it.
And that's what I'm trying to understand.
Right, that they did a joint motion to disclose but they had not seen it. I would agree with that.
All right. So what again would so then here's where I'm left. Dr. Broder comes in and he says, around the same time that in the spring of 2020, that
And I'm sorry, Judge, I did find the date. It's June 1st, 2020.
June 1st of 2020 is the order appointing him.
No, that's when he started his evaluation.
All right. That's what I thought it was for. So then I need to understand again, what is the purpose? What's the relevancy of Dr. Broder's observations of seeing the child have positive interactions with the father? And again, my assumption, I'm sorry, I assumed, was that somewhere along the lines, the parties saw the report or knew about the report. And then your theory was then the defendant said, oh, now even Dr. Broder's not supporting me. Now I have to do something else.
And I ultimately do believe, and that's what I would be arguing in a trial, that is actually what was happening. I think it's the state's argument that the defendant knew that this positive information was going to probably come out in this report.
How? How do you know she knew that?
I know from some of the interactions that were going on between her and Dr. Broder, and some of the interactions that were going on in the three people with Dr. Broder. I can impute it to her that she could see what was going on, and she could see, how Dr. Broder was leaning. And that she knew that that report was going to come out and be given to Judge Warren.
So now if I'm understanding, it's going to be Dr. Broder's observations of the interactions of the decedent with the child in the presence of the defendant and how those were positive.
I don't know, there were some that were not in her presence and some that were.
And how could she testify to the ones that were not in her presence?
Yeah, I don't see any way to make it relevant to any issue that I need to determine, but for what effect it might have on the defendant. So to the extent there were some observations of positive interactions between the decedent and his daughter when the defendant was present in the presence of Dr. Broder, I'll allow that.
Yeah.
But then that's about it.
Sorry, if you could repeat that.
Positive interactions between the decedent and his daughter in the presence of the defendant and in the presence of Dr. Broder. And then I can see how that fits in, and that is relevant to your position.
Right.
Otherwise, I just don't see the relevance of it.
And my only other argument, Judge, and you may still have the same opinion, but it also goes to the defendant's credibility, saying this child is abused, this child abused, this child abused, this child abused, and the child was acting like this, and her credibility is exactly what's at issue in this case. So.
And that's why I asked about the date. That's why I wanted to know when was he making these observations, to see if it coincided
with the reports that were being made, and it doesn't. It's several months after.
Say it was 6 weeks to 2 months afterwards.
It was. So, no, that'll be what I'll allow.
Okay, so let me make sure I have it straight because it's late. So we're not going to talk about the interactions not in the presence,
Correct?
and we're not going to talk about diagnosis.
Correct.
Okay.
Unless those later on become relevant.
Okay. In like a rebuttal or something.
Sure.
Does the court have any thoughts on cross-examination about my continuing to attack the nature of Douglas Benefield?
I'm just going to leave that open to whether it's within the scope of direct or not. It may not, and it may be. I don't know. But if it's not, then yeah, I would sustain because it's beyond the scope of direct, and then you could call him, and then it may be relevant and may be admissible. I didn't mean relevant. Admissible is the word I want. All right.
And Judge, if I could just have a moment to let him know.
Absolutely.
Okay.
So I guess we're still going to hear from him
Madam
today.
Clerk,
Yes, sir.
need a break?
I'm okay, thank you.
Yeah, we're still going to hear from him today. Hopefully this is the last witness. Okay, while we're waiting, there are some other questions. Colin Penn, Legal Bites. Would Douglas have been able to protect himself in the event of a false claim or 5, even though no charges were made against him regarding the child abuse claims? If you're talking about defamation, no, because these are claims that are made in a court proceeding, so those are privileged against defamation. In other respects, I'm not sure what you mean. I mean, because he can put on his own evidence. He can hire a lawyer to fight those allegations that are made in these claims, and that seems like that's basically what he did. So, I hope that answered your question. But if there's another aspect that I didn't answer that you were thinking of, let me know. Dionysia Jaclo says the hearing being televised does not give the jury the pre-trial / evidence facts that they aren't allowed to hear if they want a fair trial, if it is going to trial. Yeah. So in other words, the fact that this is being televised, is this spoiling the jury pool? No, because even though this is being televised widely, the community probably is very interested in the results of this case. There are inevitably going to be people who might know a thing or two about it, but only heard about what they heard about, generally speaking, and might not be watching this live stream. So that's the goal in jury selection, is to find people that haven't been following the trial. Which, case like this, yes, it's being televised, but it's not quite like some cases that are being talked about regularly on the nightly news, nationwide. You know what I mean? So I think it's reasonably likely that they can find a good jury that has not been spoiled.
Just a good, clear voice will pick up everything. Thank you, sir. Yes, ma'am.
Good afternoon. Please state your name.
Good afternoon, Dr. Brad S. Broder.
How do you spell it?
Broeder.
And it's Brad S., you said?
Yeah, S for Stephen.
Okay. What is your profession?
I'm a psychologist. Clinical psychologist is my degree.
How long have you been doing that?
I received my degree from New York back in February of 1987, and then relocated here to Florida. Started my practice in January of 98 after I was licensed here in Florida. So this is year number 36.
Okay. And what do you currently do? Do you have your own business? Do you have a practice together with someone?
I'm a solo practitioner. I have run my own business, but I do serve as a consultant to Sarasota County and Manatee County Child Protection Team.
Okay. So what is your education to be a psychologist?
Well, I first earned my master's degree in counseling psychology and then went on to pursue my doctorate in clinical psychology.
And you have a sole practice, you said?
That
Sole
is correct,
practitioner?
yes.
And you do consulting work for the county? And who is that?
Yeah,
I think in light of the court's ruling, I don't have any problem acknowledging him as an expert, and we can get on with the limited nature.
Okay.
That's fine, Judge. I just want to establish that he consults for CPT.
All right. I think that was the last thing I wrote down.
Yes.
Yep.
And what does that mean, consult for CPT? What do they ask you to do?
well, each county in the state of Florida is supposed to have a consulting psychologist because that person helps with the in-service trainings as well as attending the multidisciplinary staffings, consulting work to advise, and then if need be, called in to conduct evaluations either of a parent, a child, or both parents.
And you said that you consult with them. How are you notified when they need you?
Usually the team leader or director will contact me and let me know that what's my availability to attend to staffing. And once or twice a year, I'm on calls, let's say, to conduct seminars or workshops.
Okay. And what is a staffing?
The staffing is referred to as multidisciplinary staffing when you'd have different people that are concerned about a case. Usually if the CPI, Child Protective Investigator, has responded to an abuse call, that they will, if based on their concerns, their impressions, their observations, they may then request from CPT, the Child Protection Team, to do an overall evaluation. And based upon that, if there's some concerns or people are undecided or unsure, then we kind of meet as a group. And those people would usually be the DCF representative, supervisor, the CPI, the caseworker from the CPT team, the director or coordinator from the CPT team. If there was a medical examination conducted, there would be the nurse or practitioner there. Pardon me, myself, and usually the invitation goes out to anyone else who might know the family, the parent, or the child.
How did you become, or let me ask you, did you become involved in a case involving Ashley, Doug, and Emerson Benefield?
Yes, I did.
Okay. How did you become involved in that?
I was contacted by Ms. Kimberly Griffin from the Manatee County Child Protection Team. She was at that point the team coordinator. And they had concerns based upon
also staying as to the substance of issues
Okay.
that may have been communicated.
Based on, let me back up. So Kim Griffin is with, which agency did you say, CPT?
Manatee County.
Manatee County. And had she, to your knowledge, been involved in several prior complaints against Doug Benefield lodged by Ashley Benefield?
There had been 3 complaints in total starting in December of 2019.
Okay. And you were asked to evaluate her, Ashley Benefield, correct?
That's correct.
And were you also asked to evaluate Doug Benefield?
Yes.
Okay. And what was your purpose of, what is your goal here? You're not law enforcement, so what is your goal when you do an evaluation?
Well, sometimes the evaluation might be just parent effectiveness. Sometimes you're assessing for substance abuse. But more often than not, it's an evaluation, psychological evaluation for mental health issues.
Okay. And did you in fact complete evaluations of both parties?
I did, yes.
Okay. Were these extensive evaluations?
As a solo practitioner, I pride myself on being thorough, so I would say yes, they were absolutely extensive.
Okay. So I want to talk about Ashley Benefield for a moment, specifically. In preparation for your evaluation, did you review documents?
Part of any thorough evaluation would be looking at not just collateral contacts, interviewing other people, but collateral data, which would be whatever records are presented pertaining to the case and the family situation.
Like we're back on the Gwyneth Paltrow
I'm
case.
sorry. In addition to the fact that I typically will ask the parties, the parents in this case, if they had anything else they wanted to share with me by way of, diaries, journals, photos, videos, whatever they might have. So the more data I have, the more inclusive it can be.
And you said collateral contacts. Do you make those contacts?
Yes.
Okay.
Seems like we're going awfully far afield from what the court ruled.
I'm going to overrule. I mean, I
But
don't
give her
think
a
we've
warning.
gone into things I've ruled not to go into, but.
Okay.
Go ahead.
As part of
okay.
your work specifically with Ashley Benefield, did you meet with her?
Yes, I did.
And did you meet with her alone
Uh,
or together?
In conducting these kind of evaluations is a series of individual interviews.
Is there an objection?
Yeah, she interrupted the witness who was attempting to answer the question.
Okay, overrule. Go ahead and ask your question.
Okay. Did you meet with Ashley by herself?
Yes, I did.
Okay. Did you also meet with her with other people?
I did a home site visit. So yes, I saw her and her daughter and her mother, as well as I'd seen her and her mother in my office, and I've seen her with just Emerson. And on a separate occasion, I'd seen her and Doug together, both in terms of conducting the exchange of their daughter at my office, as well as a joint meeting.
Okay. And when you say joint meeting, is that one where they sat with you and did therapy together?
Not therapy, it's an interview for the evaluation.
An interview for the evaluation. Okay. So how many times did you meet with them together? Do you recall?
I believe at least twice where we had a formal meeting, different than when they would exchange Emerson. And the
Okay.
point of the exchange in my office, just to share, is that it's important in the evaluation to oversee and evaluate it, to observe how the child responds, leaving one parent, going to the other parent, how the parent handles the child in the separation, particularly because at that time, Emerson was just under 2.5 years old.
Okay. So she was pretty young, a toddler.
2 years, 4 months.
Okay. During your contacts with Ashley, how did she present when you first met her?
Objection. Beyond the scope of the court's ruling. The court's ruling was that Dr. Berger would be entitled to testify to his observations upon all parties being present. Ashley Benefield, Douglas Benefield, and Emerson.
And I'm sorry, go ahead. You look like
Yeah,
you
go
want to
ahead.
speak. Judge, I don't know that this has anything to do with the court's ruling. This is his evaluations of Ashley, specifically her mannerisms, her speech, what she says is all relevant.
How?
Because it goes to the allegations that were made about the child abuse, then the fact that now someone is evaluating her, now the fact that she is attempting to manipulate the evaluator goes towards the motive of the entire case.
Sustained.
Yeah. Yeah, because
What did
that's sounding a
Ashley
bit
tell
like
you
the
about
character
her
evidence issue from
relationship with
before.
Objection. Once again, beyond the scope of the court's ruling.
No, I said defendant statements we didn't get into. We didn't talk about the limits. Defendant statements weren't limited in any way. But with that said, so it's not a violation of the ruling I just made a few minutes ago, but maybe there's other objections that may be relevant or appropriate as we go through.
Are you trying to give him a hint?
But no, I mean, defendant statements they're allowed to come in under the rules. It's just a matter of whether they're relevant to any particular issues.
Did you speak with Ashley about her plans for the future with or without Doug Benefield?
Yes, that certainly came up in the scope of the overall evaluation.
And what did she say about that?
She made it very clear on more than one occasion that she had no intention of reconciling with Doug and that she had every intention of relocating to Maryland with her mother in Emerson, particularly because her grandmother had passed away and her mother had inherited that home so she could return to her native home state of Maryland.
And did she indicate to you that she was going to go without Doug? Go to Maryland without Doug?
Again, in several different occasions, she had indicated that was her intention. She did not want him to come along with her. There was some email exchanges indicating that she was trying to make that happen. He had made it clear that he was going to be going there and thought that he'd be moving in with them, which she clearly made clear to me that that was not going to happen.
Okay. So she made clear to you that he is not moving in. We are not getting back together.
Yeah, absolutely.
Did she say those things and act that way during the joint session with Doug?
No.
Okay. How was it different?
It was different in that her presentation of herself was more deferential to Doug because her goal, as she had shared with me, was to, in essence, kind of appease him, go along with him, because she was concerned he might get angry and blow up. So she wanted to just kind of go with the flow, as the expression is, and therefore she was willing to go out to lunch or go to a movie or hang out with him and Emerson. So she was not going to present that ultimate goal, certainly not with me. In those sessions, it didn't come up.
Okay. Did you talk to her about the suspected poisoning in the past? Or did she mention it to you?
That was an issue that came up, yes.
Okay. And did she believe she had been poisoned?
She was suspicious. She admitted that she didn't know for.
Jeff, she's calling for an opinion as to the substance of the comments. Did she believe?
Yeah, I mean, to the extent it asked for an opinion, I mean, we're talking about statements. What did she say?
Okay.
What were your observations?
What did she say to you about the poisoning and whether she believed or not that she was poisoned?
She had a very definite concern, a fear that he might have attempted to poison her. She was concerned first with during her pregnancy and felt ill. And then when she delivered the baby, she even stopped, didn't even want to attempt breastfeeding for fear that she had been poisoned. So she had refrained from that and went so far as to ascertain a toxicology report to that effect.
Okay. And did she ultimately admit and say, well, okay, maybe he didn't poison me?
I don't know if she certainly didn't say it that way. No.
How would she have said it?
She said, she explained to me a bunch of physical symptoms she had, and she was worried for Emerson, and she did admit that she did not know if he had poisoned his former wife, Renee, but she had that suspicion, but she could not say conclusively that he had attempted to poison her. No.
Okay. And did she indicate to you that something about, I know you're the professional here, but do you know what I'm talking about?
Yeah, I believe you're referencing towards the end of the evaluative period. She wanted a resolution, and she was very frustrated with the system, CPT, the courts, Judge Moreland, et cetera, because she felt no one was helping Emerson, no one was doing anything. I put it in my report that she declared, I'm the expert and I'm not doing anything, and what's going to happen, she'll have to take matters into her own hands.
Okay. So she indicated to you that she specifically had a problem with the authorities, MSO, CPT, CPI.
That is correct.
Okay. And at some point, did she say to you she needed all this to be done? We're running out of time.
Yes, she did.
Tell me about that. What did she say?
It was during that same interview session where she really wanted to just kind of be able to move on with her life. She was looking forward. She explained to me that her mother had retained the hope of a realtor to sell her home in the Lakewood Ranch area, that they were preparing to move. That was her intention. So she just was hoping to relocate, reestablish herself. She shared with me that if she had been able to establish a permanent residence of at least 6 months, that she could then appeal to the authorities, the Child Protective Service authorities in the state of Maryland, in hopes that they would help her.
Okay. And was she frustrated at you because you weren't helping her?
Objection.
To the extent it calls for speculation, if she made words, then that's one thing, but.
Yeah.
Did she ever express frustration or anything that would have led you to believe she was frustrated with you?
Objection.
Still speculation.
Did she say that?
Yeah, that's how I take it. I mean, hopefully I'm being very clear. We're talking about not speculation or what you think or what you guess or what might have been. We're talking about words that were uttered by that person over there.
Ashley expressed her frustration at the overall situation. To the extent that I was part of that situation, then yes, but she never specifically singled me out.
Okay. And did she indicate to you that Doug was still abusing Emerson? Or that she thought Doug was still abusing Emerson?
Not at that point, because they, at her initiative, had agreed to basically spend time with Emerson together as a family. And so there were no, during the course of my evaluative process, there were no complaints or fears about that, which she attributed to her presence.
Did she discuss with you the past allegations of abuse against Doug?
She explained each one of them, yes.
Okay. And, but she said after that they were living as a family.
Not living, they did not live or stay together. They didn't even have any intimate relations. They would do things like take Emerson to the beach or go to his condominium unit to the pool, or they would go out as a couple for dinner and grandma would watch the baby and things like that.
But Ashley told you she had no intention of being with him.
Unequivocally.
Okay. During the time that you spoke with Ashley, did she ever say that Doug physically harmed her?
Not physically, no.
Okay. Did she ever say that she was afraid of Doug being violent with her?
She explained the gun incident in their kitchen in their South Carolina home, and that was certainly a frightening experience for her.
But did she say that would have been 4 maybe years before, correct? Before you were meeting with her?
I'll sustain.
Was that incident, did it just happen or was it a long time before?
It was well before my involvement.
Okay. Did she complain of any other things, acts of violence or aggression from Doug since then?
What she explained to me about Doug was that she felt that he had a violent temper. They would get into these yelling, screaming matches, and he would punch holes in the wall. Again, that was again in their home in South Carolina.
Okay.
None of that was recent during the time I was involved with them.
Okay. So during the time that you talked with her, she never brought up anything more recent than South Carolina for violence?
If she didn't say it, it's not included in what she did say to him.
Overruled. Go ahead.
Did she give you any examples of Doug's violence, any more recent than South Carolina?
No.
Okay. Did she indicate to you that she was afraid of him while she was talking to you?
You mean in the individual sessions? Or
Yes,
just she and
yes.
She did not present as fearful or worried about that, no.
Okay. When was the last time that you saw them? Do you recall?
Approximately late August. This is 2020.
And when did you do your report?
I believe it was submitted on or about mid-September, I think the 14th of 2020.
Okay. So when a report is submitted, it gets submitted to CPT?
The work product is the property of the child protection team. So that who handles it and anyone else who wants to see it would have to get a court order from the judge.
Okay. So even the people that you're interviewing have to get a court order to get that evaluation?
That is correct.
Okay. Did your sessions with Ashley and Doug together, did you have any concerns for the safety of Ashley or the baby after your sessions?
I did not.
No further questions?
Cross?
Yes, sir. Good evening, Dr. Broder. I'm Neil Taylor. I have a few questions I'd like to ask you.
Certainly. Good evening to you too.
Only because it's the most recent, so we'll all remember it. And I recognize we're asking you questions that you're trying to answer from memory, which is not the easiest thing given the time that has transpired. But do you recall testifying at a dependency hearing?
Objection is this?
Sustained.
Okay. Are you certain about your statement that Ms. Benefield did not express fear of Douglas Benefield to you in the past and continuing in the summer of 2020?
My notes in my report reflect that she had certainly expressed fear that Doug could not parent Emerson, and she was not comfortable with him having Emerson, like for an overnight, for example. So she wanted to do whatever she could to block that.
All right, may I approach the witness, Your Honor?
Okay.
Let me pass this to you and see if this helps refresh your recollection. Does that help refresh your recollection as to whether or not Ms. Benefield during the summer of 2020 expressed to you that she was afraid of Douglas Benefield?
Yes, based upon the previous experiences in South Carolina.
All right, now the judge has restricted us, as Ms. O'Donnell told you, to things that Ms. Benefield told you. And you've been very candid and helpful, but I want to just ask you a few additional questions. She told you, among other things, did she not, that Doug had he was very angry with a real temper?
She expressed that he would get very angry, yes.
She expressed to you, told you that he was very controlling.
She certainly felt he was controlling, yes.
Yeah. In fact, I believe she said to you that he was highly manipulative.
I don't know if she used those exact words, but she felt that he was controlling, yes.
Let me see if I can refresh your recollection. May I approach him, Your Honor?
Yes.
I'd see if that refreshes your recollection as to whether or not Ms. Benefield told you that Doug Benefield was highly manipulative in those exact words.
That's my statement, yes.
She told you that he was very intense,
Yes,
that he punched holes in the wall,
that's true.
fired a gun in the ceiling of the kitchen. And she discussed with you her fear that he'd poisoned his first wife and perhaps her as well.
She admitted that she didn't have any proof of that, but she was suspicious that he had poisoned Renee and that she therefore had similar suspicions that he might attempt to get rid of her.
All right, and lastly, I want to ask you, you mentioned, and I think the word that you used was appeasement. This was the strategy that Miss Benefield told you she employed for going along with Douglas Benefield in an effort to protect her child, Emerson, correct?
She felt the best way to protect Emerson was to
Sorry, guys. Didn't mean to pause it. One of my earbuds are starting to
appease
die,
them,
so I'm
yes.
charging one of
Yes.
them.
I believe the way you characterized it was to keep him, Douglas, at bay.
yes.
Nothing further.
All right,
Thank you, Doctor.
redirect.
Okay, redirect.
So defense just asked you about Ashley saying she would go along with Doug to protect Emerson, to keep Doug at bay, correct? Did you have any concerns about Doug being with Emerson?
Objection.
The door has been opened, Judge.
You know what? I'm going to allow it. I think the question was asked. Go ahead.
Did you have any concerns about Doug being with Emerson alone?
Well, let's put that in context. When you're doing these kind of evaluations, you have all sorts of hypotheses to start out with. But as part of the evaluation, I have to see parent and child together, both in terms of the separation from one parent to the other, as well as their interaction. After observing him with Emerson, and the first time just happened to be due to scheduling issues at his own apartment, I did not have any concerns at all.
Okay. And did you observe the two of them together?
Yes,
The child and the father?
yes.
Okay. And was there anything about their interaction that stood out to you?
Emerson had been with her dad in the pool that afternoon prior to my arrival. And when I got there, she had just woken up from a nap. I was a complete stranger to her, and she therefore clung to her father and stayed on his lap and cradled herself. And he was comforting her and soothing her. And I kept my distance as he and I talked, and it was pretty clear that even as she's waking up, she was looking to him for comfort.
Okay.
Yeah.
And so Ashley says she's staying with Doug just to protect her daughter. But this is a situation where CPT and law enforcement had all been involved, and it culminates in you. And did you have any concern about Doug being with his daughter?
Already asked that.
I'll sustain. That's been asked and answered.
Yeah.
So Ashley said to you that Doug could be violent or angry, punch a hole in a wall, things that happened in South Carolina, correct?
Yes.
Did she ever say anything to you like, I am so scared he comes after me all the time?
No, she never used that expression or that phrase.
Did she ever say, I was afraid anytime that he was going to hit me?
No, she never expressed that at all.
But yet she's scared because he's so violent. Correct. She said she's scared of him because he has a violent tendency.
Yes, but the context was typically about how can she best protect Emerson, and how come I and the rest of the quote unquote system were not doing enough to protect Emerson.
Okay. Thank you. No further questions.
Nothing further.
All right. Can the witness be released?
Yes.
Yes.
All right. So you're releasing your subpoena. Thank you very much.
Thank you, Your Honor.
You take your water with you if you want.
Okay. Hopefully that's the last witness of the day.
Dare I ask? Oh, well then, you solve that issue.
Yes.
I was going to be the bad guy and say, call the next one. But
Yeah.
that was not a popular opinion, just so you know. All right. Any idea? Can you give me an idea for planning purposes for tomorrow?
Judge, I think it will be the defense case tomorrow.
Okay. I'm not, so don't rest yet, but, all right. So be ready. You may be,
Yes, sir.
they may call you from the bullpen right away, all right?
Signal for the right.
All right, anything that we need to cover tonight before I let you go?
I don't think so.
All right. Defense, good. All right, so we'll get started tomorrow. Oh, you know what? Hold on. I think I have some. Let me just check, because I got a demand for speedy trial. Let me just make sure I didn't schedule that for tomorrow morning. No, it's you guys all day, so you're all set.
All right.
8:30?
8:30 again.
8? You want to start at 8?
No.
Oh, I thought you wanted to go earlier.
We're good, Judge. Thank you.
All right.
Thank you
All right, we'll see you at 8:30 tomorrow morning.
Okay.
And listen, hey, I know traffic has been horrible, so if you run into some traffic issues, please don't anybody stress about that. All right, if we're a few minutes late because of that, we're just
This
fine.
is a
Don't
very
worry.
kind and considerate
See
judge.
you tomorrow morning.
He's like, don't stress about traffic. If you're a little late, that's okay. That's crazy. So, okay, we'll take the feed off of here now. And well, that was a very interesting day. Let's get some final questions here because we've got some questions that I saved. First off, Draco Amy, what is the significance of putting things on the record? Is it about future trial / appeals education? It is about the potential for appeals in this particular case. For this particular hearing. So sometimes it can be helpful for other cases as well later on, depending on what the ruling is, what the the eventual kind of opinion is. Oh, if you guys want to see, actually here, adding, you can see her here. So we've been looking at the back of her head this entire time, but here she is. For the first time, we are seeing her face today. So yes, but for the primary purpose here is to get it on the record in case someone wants to appeal some kind of a decision. So yeah. Mike Keeney, Legal Bites. What do you think about the judge and the attorneys? I think the judge is great. I really like this judge. I like the fact that he's very knowledgeable. He's very quick. He's very precise. Like he's also like not really allowing any crazy nonsense, but at the same time he's also very kind. And I think part of it too is the fact that he has two very professional attorneys that he's working with. We probably would see a very different side to him if the attorneys were less professional, but here on both sides I think that the attorneys are very professional. They're even though the defense attorney for a bit during the cross-examination of that one detective, he was really going down a whole different rabbit hole. I think that was just zealous advocacy. And he really was trying to push as far as he could possibly push down a particular avenue. So, but overall, I think that all sides here are very professional. So this is great to watch, to see the arguments going back and forth between the two sides. And yeah, to answer questions also, by the way, about her age. Yes, she is quite young. So when they met, he was 54, she was 24. He was more than twice her age. And that was 2016, I think, something like that. So, and then when he died, he was just shy of 58. So she was 28. Yeah, she's young. She's quite young. She's really only like 10 years older than his daughter from his first marriage. So that definitely, how much does that change people's perceptions of their relationship too? Number one, that age difference can make a difference for coercion within a relationship. Or was she someone who kind of manipulated her way into his life for his money, for his, like, start up a national ballet for me, let's make a baby for me, regardless of the fact that you previously decided to have a vasectomy? That can cut both ways. Honestly, that age difference, it really could. So, yeah, and she's not in custody. She's out on bail. Thank you, Ashley Boyer. She's 28 or 29 now. Yes. So yeah, she is quite young in comparison to him. But like I said, it could cut both ways. Draco Amy, I'm curious, does the judge ever deny approaching a witness? What happens then? Well, usually if the judge is, yes, judges do have the ability to do that. Usually it's going to be that the attorney who is trying to do something hasn't really like laid a proper foundation for what it is that they're trying to do, or hasn't one second here. Or, hasn't made it clear that they are trying to impeach a witness, or trying to, refresh the recollection of a witness, or trying to show the witness something in particular that they, that is crucial for the testimony. If it's unclear to the judge why the attorney is doing that, then the judge is probably going to pause and be like, "Whoa, what are you doing? What's going on? Let's back up for a second. Let's clarify this." And usually it's going to be something like where you kind of like work through an awkward moment, and then either the attorney is able to explain herself or himself, and the judge is like, "Oh, okay, that's fine," or the judge is going to be like, "No, move on." So yeah. Debbie Faison Cook, this is her doctor, right? Did she waive privilege? How is this allowed? So that last witness, Dr. Broder, was not her doctor. He was a doctor that was assigned by Child Protective, the Child Protective team in Florida. It's like the same thing, Child Protective Services, a state agency that looks over these kinds of cases where child abuse is alleged. So he was sort of brought in as a to give consulting, as a consultant for the child protective case in this matter. And so yeah, so he was assigned to them because she I think both of them had to submit themselves to a psych evaluation. The state with an earlier witness, the state mentioned that Doug had agreed to undergo a psych evaluation. So it appears that they both did here. Let's see. I think there might be some new questions here in the chat. Oh, or at least one more. Kaylee says, Legal Bites, what do you make of her telling professionals one thing while telling and behaving with him a different way? Is this an abused woman getting sucked into the cycle, or a malingerer? It is so hard to tell, especially with the evidence that we have seen so far. At least, I mean, for me, I really probably won't be able to tell you my thoughts on that until we hear from her herself. I anticipate that she probably will testify, because there's just a lot here that is like her making allegations. And her having made allegations, so it's like, I think that in order for her to win this here at the stage, she's probably going to need to testify. That's my opinion, even though she does have a Fifth Amendment right not to testify. And also there's a question about, there's Judge Matt White. That's the name of the judge. I see that in the chat. Some some folks were asking. White is Whyte. So Judge Matt White. Do you think the daughter will testify? That's a really good question, actually. I don't know. From what it sounded like, the state it sounded like the state is basically resting in this hearing. And that the defense is going to be putting on their witnesses tomorrow. So they haven't quite rested yet, because I guess there might be like one or two things to handle before that happens. But it just sounds like they're pretty much done with their part. I mean, this is a 2-day hearing. Remember, this is a mini trial. I would anticipate if this does actually go to trial, we probably will hear from her, because I mean, at the very least, this is somebody who is testifying to the loss of a family member, and what he was like, and there's just a lot there. It would be beneficial in this hearing to hear from the daughter, for sure, unless the state really thinks that they don't need her. We'll see what tomorrow looks like. So, and on that note, tomorrow, day 2 of the hearing is going to be 8:30 a.m. East Coast time. We will be going live here. Normally on Fridays, we do have our Bite Club 1-hour stream at 10 a.m. East Coast time. I'm going to be pushing that off to another time. Might do it over the weekend, but there's still Lawyers and Dragons on Saturday. I'm going to try to figure out when we can do that, to have our casual weekly members only hangout stream, especially because we've got some new folks that have been added after today. So I definitely want to try to do that if I can manage it. But I'm also going to be jumping into the next deep dive video after this as well. So trying to get that out as quickly as possible. It's just the work. The hits just keep on rolling, right? Which is great. It's wonderful. I love the fact that there's so much law going on, so much stuff to talk about. So this case in particular, I really appreciate. Shout out to Reindeer, she's in the chat, for actually emailing me about this hearing. It wasn't even on my radar at all. Asked if I could cover it, so I put the poll out for that. And I'm very glad that you did. I'm glad you reached out, because this is a very, very interesting case. So, excuse me. I don't mean to be yawning on a stream. I know I do this sometimes. But it is getting a little bit late here. So, yeah, Indies in Snoozer Town for sure. So, okay. So anyway, if you guys want to see tomorrow, 8:30 a.m. we will be going live as soon as there's a court feed up. We will be going live. I will try to set up that stream in advance so that it is just there and ready to go. So be on the lookout for links to that in advance. And otherwise, I think that's about it. Okay. All righty. Thank you guys. And thank you to everyone in the chat. I know that there's been all kinds of discussion in the chat about one way or another. Oops. One of my earbuds, the other earbud just died. So I know that there's been all kinds of chat about one side, the other side. This is so not a clear cut case, in my opinion, at this point. But I know that people have had opinions about her, opinions about him, and I love the fact that it has been respectful up, so far, as usual has been in the case in this chat. So thank you to everyone for participating in that engagement, in that conversation, and doing so in a way that is still respectful of other people's stances and other people's opinions. And thank you once again, and as always, to the mods for helping to usher that discussion and keep it moving forward the way that we love to see it happen. So always thank you to the mods. I know that Shireen's already out, so she had to sign out before, but Sandra Ramirez, Kit Kat, I hope I'm not forgetting anyone else. Thank you guys. Thank you so much for doing that. And okay, all right, that's about it. We will be ending for the day, and hopefully I'll see you guys tomorrow. Right. At any rate, I'll see you in the next video.